Met, Your Lordship. Lord, I beg to mention item number 1.
Yes.
Lord, in this case, Lord, I have been engaged recently. So I have some difficulty. Lord, can this matter be adjourned for 2 weeks?
Okay. Yes, Mr.
I would like to. I am inquiring.
Yes. When do you? Yes, when do you want, Mr. Rasgupta?
Then in that case, on 4th of May.
Let him.
After 2 weeks, Lord.
Any interim order is operating?
No.
It's about the constructions of 6 numbers of bridges. And due to tendency of the present appeal notice. The work is on 4th of May.
Interim order.
Yes.
In fact, we are inquiring for the respondent, Lord.
State Council is proposing a date on 4th of May.
4th of May. 4th of May have some difficulty, my Lord.
In that week, any other date?
After 2 weeks, it will be convenient for me, my Lord.
6 May.
6th of May?
Can we adjourn for 2 weeks, my Lord?
Okay, 12th of May, 12th of May. 12th of May, exactly 2 weeks. Yes.
The interim pass are there.
Only till the next date. Okay. Mr. A. Dasgupta, learned senior counsel appearing for the respondent, has made a request for accommodation for 2 weeks. Mr. So-and-so, learned so-and-so has submitted, appearing for the appellants has submitted that has expressed urgency in the matter. Has this expressed urgency in the appeals. Post up as sought for by Mr. Dasgupta and agreed to by the Landstein Council for the appellants. List the appeals on 12/5/2026. Post up. The interim order passed earlier shall continue till the next date of listing. Post up. As the
Can it be on
yes,
13th May? 12th May have a
we here generally the division bench sits on Tuesday and Thursday. Tuesday and Thursday.
Next Tuesday, no? After 13th, after 12th.
No, it will be difficult. They are expressing urgency. Public projects.
One case is fixed, no? That is the problem.
8 is Sunday. Or 8.
No, all that. Can it be 14th or 15th May?
8 of May is okay.
18th.
8 is Friday.
Please try to find make
All that it will be on 12th.
12. Interim order passed early. Shall continue till the next listing. Interim order.
Lordship,
Yes.
I would like to mention item number 6 and 7, Your Lordship. Lordship, kindly take up this matter on 30th, Your Lordship.
On
30th, Your Lordship.
30th April.
30 of this month, Your Lordship. I've taken the
30.
consent.
30 will be difficult for the court. We can take up today if the petition is ready.
Lordship, I have some difficulty today, Lordship, kindly.
Then it will roll over to next week. On the pair of Swens. Learned counsel for the state respondents. Leaves the case on Swens. Next week, which date?
You want 6th, Lordship, then?
6th of May.
Lordship.
6th of May, 2026. It is submitted that consent has been taken for the learned counsel for the petition to make the prayer. Similarly, sim 7.
Lordship.
Both are same.
Yes, Your Lordship. Obligation.
Yes.
Your Lordship, I beg to mention item number 9 and 10. Your Lordship.
9 and 10.
I'm appearing on behalf of my learned senior counsel, T.P. Tara. He couldn't make it today due to some personal difficulties, sir.
Okay.
Therefore, I request Your Lordship to kindly grant her some time for filing the rejoinder.
Rejoinder.
Yes,
How much time you need?
Sir, 1 week.
You have informed the other side?
Yes, sir.
Okay.
Melo, I'm
Mr.
there, Melo.
Okay. Mr.
Dolo Yang for, sir.
Learned counsel on behalf of Mr. T.T. Tara, learned senior counsel for the appellants, has made prepare for adjournment on the ground that Mr. Tara is out of station due to personal reasons. So, Mr. B.K. Singh, learned standing counsel FCI, has appeared through a virtual mode. Has appeared through the virtual mode. Post of Mr. So-and-so has prayed for and is granted. How much time you need
Sir, 1 week.
to file a reply affidavit to the affidavit of opposition filed by the respondent FCA authorities? 1 week.
Yes, Your Lordship.
Lays the case on so-and-so.
Melo,
Similarly-
let the matter may come up after 3 weeks, Melo. Let them
Okay.
file their rejoinder.
Okay. 3 weeks time. Lays the case on so-and-so. Similarly, item number 10. Same order.
Obliged,
Much
Melo.
obliged.
Item number 1.
Yes.
Your Lordship, kindly this matter may be passed over for the time being.
Item number 2.
My lord, before my friend starts, my lord, last time your lordship were directed to get some instruction. My lord, we have received the instruction, my lord. In the meantime, my friend, he can state his argument, my lord. We have received the instruction.
You have received instruction.
Yes, my lord.
My lord, this petition is, my lord, directed against the impugned transfer order dated 15/9/2025, my lord. Basically, the ground, my lord, that frequent transfers, my lord, within a period of 1 year, my lord, for 4 times, the petitioner has been subjected to transfer frequent, my lord. And the last transfer was within the 4 months period, my lord, from the earlier transfer. my
Let
lord.
us see the first transfer
First transfer.
in the
my lord.
series of transfers.
My lord, my lord. I will. May I take, my lord, page number 20, my lord? Starts from page number 20 onwards, my lord. This one, my lord, it's on 15 October 2024. Hanu Mangfi, serial number 2, my lord, is the petitioner. A Bumming subdivision as A Balijan, my lord. 15 October 2024, my lord. Thereafter, my lord, this order was modified. My lord will find it page number 22 type copy, my lord. This order was modified, but my lord.
15 October, 15.
Yes, my lord. This,
Nobody had joined.
my lord, nobody.
Nobody had joined.
My lord, my lord. So this order was modified, my lord. And A under order, thereafter he was transferred as SW SEPA division, my lord. On January 2025. So he joined thereafter SEPA, ASW SEPA, my lord. Then, my lord, within January 2025, thereafter, my lord will find within May, my lord, kindly page number 23, my lord. My lord.
Yes.
My lord. Page number 23, my lord. Then within May, my lord, on 17 May itself, within 5 months, again petitioner was transferred from ASW SEPA to PIPU subdivision, my lord. My lord,
So first order, transfer order was not affected.
my lord, it was modified, my lord.
It was modified. Nobody had joined.
My lord.
First transfer order was, there was reliever.
My lord.
But second transfer order, there was vacancy, existing vacancy.
My lord.
So you joined there
My lord.
as SEPA, at SEPA.
At SEPA.
Yes. Then
My lord,
third transfer order, that
third
is
transfer,
page
my lord.
23. SEPA to PIPU.
My lord.
Hmm.
Then from now, my lord, 17 May, from SEPA to PIPU, my lord.
Hmm.
Then, my lord, impugn transfer.
When did you join?
My lord, thereafter, immediately I joined, my lord. Then, my lord, you'll find impugn order at page number 19, my lord. Then, my lord, within 4 months, my lord, September.
Hmm.
9 September.
Hmm.
Sign, it's on showing 15 September.
Hmm.
My name at serial number 3, my lord.
Hmm.
Then within 4 months again, my lord, transferred again to my lord PG rank subdivision. But till today, my lord, since no reliever has been posted, my lord, till today I am functioning there from, my lord, and moreover protected by the interim order of this honorable court again, my lord. So I am still serving there.
Protected.
My lord. So, my lord, basically, my lord, then representation I filed, my lord. It's still yet to be considered the representation, my lord.
Protected till filing of the representation. Oh, sorry.
No, affidavit, my lord.
So basically, it is third.
Third, my lord, since one was modified. Third, my lord.
Before joining,
My
you stay put in your original place of posting, so it was not affected.
My lord.
So second first transfer order was again modified.
Yes, my lord. This is
by the
basically,
third order.
my lord, 3 transfer, so to say within a period of
Huh.
1 year. So basically,
Just a minute. What is this note? It is available in your record.
Which note, my lord? That must be a transfer order, my lord.
No, no, no.
In public interest. You're also referring to my lord, 9th September, my lord?
9 September.
Yes, my lord.
That note is annexed.
Oh, yes.
19, page 19.
My lord, this is the e-file, my lord, moved, my lord. This is the e-file.
Mhm.
Reason is given, my lord.
Let me read.
My lord.
It is not that, Mr. Sona, that this has been issued hurriedly. That these Pizrang, Pizirang has been identified as priority areas.
I understand.
Priority areas. That is why it is not that you only has been identified. There were total 7 were identified initially. Out of them, few were junior engineers, 3, to post as assistant engineer. Then they dropped the idea that junior engineer should not be placed in the post of assistant engineer. Then they left aside those junior engineers. Ultimately, 5 assistant engineers were sought to be transferred to priority areas where ongoing works are there. That is a noting that several divisions, subdivisions are functioning without full-time assistant engineers, affecting field operations and project monitoring. To address this, it is proposed to transfer post officer based on field requirements, administrative convenience, and to ensure optimal manpower utilization, particularly in priority areas like Diun, PG Riang, Nafra, Dambuk, and Kanubari. So it is that there are 7 names were proposed. Junior engineers were taken out. then 5 assistant engineers were identified, but competent authorities say that there is some problem with one that needs discussion, but for other 4, that order has been passed. It is not that hurriedly this has been passed. The thing was initiated on 28th of August in the file. You can have a look if you want. Yes, Mr. Naba,
My lord.
what is the new instruction?
My lord, so far, because as on today, I've not been furnished even with the, my lord, this relevant, my lord, records, in which, because.
But if it
RTI
is said to be a office file digitally maintained,
Yes, my lord, may I take,
we have to-
to my lord, page number 25?
your RTI,
Yes, my lord.
I have seen.
My lord. So my lord, may I pray, my lord, that let the government file bring these things on record, my lord, by way of affidavit, my lord, so that I will have my lord, a further discussion with my client, and if any instructions required, my lord.
Yes, Mr. Naum, they have right to reply. So you take this back, you get it on record.
Well, that's all right. But as for that,
You can have an inspection.
Yeah,
if
as for the
these
letter
are official
instruction, my lord,
files.
as per the letter instruction, my lord, since there is a vacancy, he'll be releasing very soon, my lord. The last part will not.
No, he has a right to reply at least.
No doubt about that, my lord. But
You
facts will
file
remain
it,
same.
bring it on record.
But the facts will remain same, my lord.
Things will remain same.
Facts will remain
But
same.
he says that at least he should have the satisfaction of filing a reply.
Correct, my lord. These are technical
My lord,
issues. my lord.
another issue.
Technical issues.
Technical issues.
Otherwise, again, he will go on appeal.
My lord,
Better
saying
to-
that, fair
better
chance
to
was not given.
Complete order for formalities. When can you bring this on record? There is no harm bringing on record.
Yes, my lord. Not at
Bring
all,
it
my
on
lord. These
record.
are
You can
official
take-
record, my lord.
These are official record. You can
Correct.
take it back,
My lord.
file a reply,
Affidavit.
so that Mr. Sonar can have an opportunity to reply.
Especially, my lord, in view of RTI reply is also there. They are having 2 reasons, my lord.
Okay.
My lord, whatever RTI reply says, but e-file, my lord, will never tell lie, my lord. That is the record, my lord.
That is why I thought that it can be decided, but since he has asked for a reply, at least he has a right to file a rejoinder.
Okay.
Let him do it. When can you file?
My lord, within this week, my lord, no issue. my lord.
Okay. By Friday you file it?
My lord,
Oh, sorry, it will be Thursday.
today is Monday, my lord.
Friday is holiday.
Only for this annexing document we can file today itself, my lord. If your lordship allow us to file the affidavit, my lord, not the officer but the government advocate, we can file it today itself.
But he may have to contact. He would need 1 week time. Okay, you file it by Thursday,
My lord.
so that it can be taken up on next Wednesday.
My lord, not Wednesday, Monday, my lord, next Monday, my lord, for final disposal, my lord, either this way or that way, my lord.
But he has a right to reply.
Let him first file, but thereafter
My
I
lord,
will
what
have,
I'm
my
saying,
lord.
my lord, we can, if your lordship allow us to file, my lord,
You file it by
my
tomorrow.
lord, by tomorrow itself, my lord, we can annex this document in the form of affidavit, my lord. After that, he can go through whatever reply he wants to file, he can file, my lord.
Within 1 week next.
Let him first file, my lord. Thereafter, my lord,
Don't worry, we'll file
I
within.
need to have an instruction.
I had Mr. R. Sonar, learned counsel for the petitioner, and Mr. R. Isnavan, learned additional advocate general Assam for the respondent number 1 for the state respondents. Full stop. Mr. Nawam has received a written instruction and the relevant file notings leading to the impugned order of transfer dated 9/9/2025. Full stop. He has submitted that he will bring the same on record by way of an affidavit in opposition, which will be filed by tomorrow.
My lord.
Full stop. Let the case be listed on Monday.
My lord, the last time, my lord, some technical issue was raised by my lord Justice Sorana, my lord. My lord, without any specific order from this court, my lord. Now the government advocate cannot file, my lord, to annex those documents in the form of affidavit. So you lordship may clarify that point, my lord. The government advocates are allowed, my lord, to file those document in the form of affidavit, my lord.
What technical objection?
Well, basically, affidavits are filed by the officers, my lord, authorized officer. And
It has to be filed by the
Yes.
officer.
if your lordship allow us, my lord, by instead of my lord, officer swearing in, a government advocate can file that affidavit by annexing those
No, that
documents.
will be difficult.
Like that technical issue was raised by my lord. Yes.
Officer, let
Officer has to
file-
file the affidavit.
That is for the affidavit. I'm asking for just my lord to bring the records, my lord.
No, this will be affidavit only.
Affidavit only, my lord.
This will be affidavit in the form of
In
affidavit
the form
only.
of
There is no
affidavit.
other way.
Yes.
Then
But
my lord,
affidavit has to be filed by the deponent.
then my lord, officer has to file, my lord.
Yes.
Just to bring on record, my lord.
No.
Sometime, my
I
lord.
have said affidavit in opposition.
My lord.
You have to file it by way of an affidavit. And that is by the officer.
Then my lord will be recorded some longer period, my lord.
Yes.
Then,
Thursday?
my lord, by Thursday, yes, my lord. Thursday or
Thursday.
Friday, my lord.
Oh, stop. List the case on 8th of May.
8th of
The petitioner shall ensure that its affidavit in reply, if any, is filed before 8th of May.
my lord. Very well, my lord.
My lord,
The interim order.
my-
You can take it back
My lord, yes.
for your use. Give it.
interim order may kindly we can.
I have said,
My-
interim order passed, it shall continue till the next.
Item number 3.
Then we can issue notice.
My lord, yes, my lord.
Yes.
Notice can be issued
Ah.
because sooner.
Let notice be issued.
Should it happen?
Notice is made returnable on 8th of May.
My lord.
8th of May. As Mr. Navam has appeared and accepted notice on behalf of all the respondents, issuance of formal notice to the respondent is dispensed with. Now, extra copy. You don't need extra copy.
My lord, if your lordship issuing the notice, yes,
Yes,
but we
Mrs.
require,
Sonar.
my lord. Extra requisite copy,
Mr.
my lord.
Sonar, Land Council for Petitions shall furnish two number of
Requisite copy, my lord.
two copies of the petition along with an extra to Mr. Navam during the course of the day.
Correct.
By affidavit to by 30th of Thursday, or affidavit reply by so and so interim order. Yes.
Yes, Mayor, Your Honor. Yes, Your Lordship, this writ petition is being filed on the behalf of petitioner, Your Honor, who was, Your Honor, serving as a sub-accountant and ex-in-charge manager.
You are employee of a bank.
Yes,
bank.
Your Honor. Yes, Your Honor.
Okay.
Petitioner is, Your Honor, it's a
Prolonged suspension.
Yes, Your Honor, for prolonged
Issue
suspension.
notice
Yes, Your Honor.
at Mr. Zilen,
Yes, Your Honor.
L. Zilen, learned counsel for the petitioner. And Miss
Lordship, I am here for one
One.
only. One only. I am for one.
Miss
G at the
Z.
Okay.
G. Learned additional senior government advocate for the respondent number 1. Post of aggrieved. By prolonged suspension. Since
2023.
21/01/2023
Yes, Your Lordship.
without initiation of any disciplinary proceeding.
Yes, Your Honor. Neither it has been reviewed. Your Honor.
The petition has approached before this court by the instant writ petition, assailing the action of prolonged suspension. First of the petitioner has contended that the prolonged suspension of more than 3 years
Yes, Your Honor.
without initiation of any disciplinary proceeding has taken the color of penalty. First of review You are raising anything?
No, Your Honor. It neither reviewed, Your Honor.
Okay.
Yeah.
It is a case of the petitioner that while prolonging the suspension periods from time to time, no review was made to pass any region order justifying the extension of suspension. Issue notice returnable on after 4 weeks, give a date. As Ms. Ete, learned additional senior government advocate for the respondent, has appeared and accepted notice on behalf of the respondent number 1, issuance of formal notice to the respondent number 1 is dispensed with. However, an extra copy. The petitioner shall take steps for service of notice upon the respondent number 2 and the respondent number 3 by speed post within 3 working days from today.
Your Honor, item number 5, same issue, Your Honor. The respondent is same, but petitioner and the branch is different, Your Honor.
Okay, item number 5. The order of suspension date
9 February, Your Honor, 2023.
9 February
2023. Or the suspension date and branch is different and petitioner is different. Your Honor.
Same respondents are same, huh? So respondent number 1, for respondent number 1, Ms. Ete. Same. Returnable date
28 May,
28 May 20 or 28
28
28 05 2023.
Much obliged, Your Honor.
of lights. Item number 4, 28 May.
May I please, my lord? My lord, by and letter dated, my lord, issued by the IOC, my lord, 6/4/2025, my lord.
Just a minute. Yes, which page?
My lord, page 117, my lord. 113, my lord.
100.
112 is the, my lord, letter.
113.
13 is the operating part, my lord.
Let us read.
The entire letter, my lord.
Let me read.
May I, please, my lord?
I can read. You can
I will also read, my lord. Please refer our previous letter by reference number such and such dated 17/4/2025, where it was advised to submit fresh reconstitution proposal in line with the prevailing reconstitution guidelines of the corporation within 6 months of the issuance of the court order dated 27/2/2025. However, you have still not submitted the reconstitution.
What is this court order?
Well, the lordship will find at page 105, my lord. Order dated 2/105.
What does it order?
It's, my lord, by my lord, relevant paragraph is at, my lord, page 11 onwards, my lord. 107, my lord.
In terms of
subclause 10 of the clause G of the policy guideline, in case temporary arrangement for operation of the dealership continues beyond 6 months, the option has to be given by corporation to run the dealership under the holiday scheme to surviving partners for sorting out their issues within the reasonable time and revert back for the dealership. In terms of the aforesaid clause, the burden is upon all the partners to come out with an amicable solution, failing which the corporation would have not to proceed under subclause 10 of the clause G. Therefore, in the particular facts of the case, ends of the justice would be met if the legal heirs of the original owners, partners, and other stakeholders may be given liberty to sort out their differences and to revert to the respondent corporation for reconstitution of the firm, ordered accordingly. It is provided that if the above process is not completed within a period of 6 months from the date of communication that may be issued in this regard by IOC to petitioner, the respondent number 4, and or any other stakeholders, the respondent corporation shall be at liberty to take appropriate steps as per the applicable guidelines. In the interest of the justice,
you are the petitioner there.
Here I am the petitioner, my lord.
No, in the earlier petition?
Yes, my lord.
And any contesting respondent?
No, my lord. The respondent
is respondent number 4 there.
Yes, my lord. He has not appeared in the, my lord, earlier writ petition also, my lord. And he has not contested that writ petition also, my lord. My lord, the fact of the case is that, my lord,
Hmm.
my lord, initially, my lord, a letter of intent was issued.
Let me read this order. If you order, then we can.
My lord, my lord.
Oh, sir. Unnecessary is a beach site retail as a commission in and was issued in February. G. Term.
139.
Letter was reconstituted as partnership formed by inducting Manto Company as partner of 50%. A balance was retained by the original Regi Company. Subsequent Regi Company had expired. Manto Company had expired.
My lord, should I read, my lord, and clarify, my lord?
Has proprietorship. Why they are saying that all legal heirs of the deceased partners?
My lord.
Huh?
My lord, because, my lord, initially the...
Bami Kamdak had lodged a complaint.
Yes.
Regarding above proposed constitution. From the complaint, it appears there is
From the complaint, it appears there is
legal heir of the original partners or sales and supplies was suspended 2021. He filed a suit for suspension of supplies. The government had stayed the suspension and directed ISL to restore the supplies. In continuation, another order has been passed. Yes, you have not, that is what their ground. You have not submitted fresh reconstitution proposal.
Yes, my lord. Because, my lord, my lord, application is still pending before them, my lord. That has not been disposed of, my lord. Now they are saying that the High Court, earlier this Honorable Court never said that we should file a fresh proposal, my lord. They only said, the Honorable High Court has only said that, my lord, try to, my lord, resolve within yourselves, my lord, between the legal heirs and to revert back to the, my lord, corporation, my lord.
Right.
That is the man. And, my lord,
because this Bami Kamdak has lodged a complaint. That has raised the issue.
Yes, my lord. My submission is that, my lord, initially, my lord, the reconstitution was made on basis of a, my lord, partnership deed, my lord, one partnership deed, my lord, which is a, my lord, a partnership at will, my lord. Under Section 7 of the Partnership Act, my lord, partnership at will is being defined, my lord. It is the will be determination of the deed will be, my lord, at the wills of the both the parties, my lord. Here, my lord, after the, my lord, my lord, the agreement has been, my lord.
After this Rijijir,
my lord, has inducted.
Rijijir Kamdak had inducted your father,
No,
right?
As a partner, my lord.
Mendo Kamdak.
Yes.
So it became a partnership firm that was recognized by the IOC.
IOC, my lord.
And it was allowed to run the outlet, petrol outlet, distributors.
Yes, my lord.
Right?
Yes.
50-50 basis.
Yes, my lord.
Then what happened?
Thereafter, my lord, the Rizir Kamdak, my lord, who is one of the partner, my lord, was appointed as a government employee in the state of Arunachal Pradesh, my lord. And he subsequently, my lord, relinquished his partnership, my lord, by duly filing an affidavit also, my lord. And I became the sole proprietorship of that farm, my lord.
You or your father?
My father, my lord.
Yes.
Then, my lord, in the year 2017, my lord, my father expired.
But before that, after that, Rijiji Kamdak,
yes, ma'am.
He resigned from the relinquished
from the
right
partnership,
his partnership.
So my
from the
father,
farm, whether your father
yes, my father
submitted any application
yes,
for
my lord.
reconstitution
My lord,
from partnership to proprietor.
Yes, my lord.
Whether that has been recognized by the IOC?
No, my lord. That has not been considered, my lord. But, my lord, my father continued, my lord, to operate that outlet.
But when did your father apply it?
My lord, lordship, I have given in my paragraph, my lord. My lord, page 12, kindly see, my lord. Paragraph 5, my lord.
Paragraph 5.
5, my lord.
Paragraph 5.
Page 12, my lord. May I read, my lord? The petitioner begged to state that on being induction of rigid conduct, one of the partner, since deceased, into government service, the petitioner's father, Bento Kamdak, since deceased, submitted an application before the Assistant Manager IOC Limited Tezpur along with requisite documents for reconstitution of RO dealership in the name of petitioner's father, late Bento Kamdak. The said application along
But
with
on this 15/1/2001, how can it be? Huh?
my lord.
How
On
can it be?
Yes, my lord.
When it was okay, when he got the government service?
My lord, my lord, kindly see, his, my lord.
When he got the government service?
In, my lord, kindly see, my lord, that has been in his affidavit, my lord. Kindly see, my lord.
Where is that acknowledgement?
My lord,
15/1/2001.
Page 55, my lord.
55.
Page 55, kindly, my lord, pause for a moment, my lord.
55.
No,
55 is
kindly, my lord, page 55B, my lord.
55B.
My lord. He is this intimation, my lord, to the sales manager, my lord. To the sales manager, Indian Oil Corporation, Assam Digboy. Approval for reconstitution of dealership.
But that is 1993.
That is prior to, my lord. Page 88, my lord.
80.
And the affidavit is also at page 89, my lord. Kindly, I'm extremely sorry, my lord. Page 89, my lord.
89.
This is the affidavit, my lord.
Affidavit is okay.
My lord.
But when did you your father wrote to the IOC?
My lord, 20, my lord. That is what I have mentioned in paragraph, my lord. 5, my lord. Just read, my lord.
You have said the said application.
Yes, my lord.
C. The petitioner begs to state that on being on induction of Rijiji Kamak into government service, the petitioner's father, Mento Kamdak, submitted an application before the assistant manager,
my lord,
along with requisite document for constitution of RO dealership in the name of the petitioner's father.
Yes, my lord.
Let Mento Kamdak. The said application, along with aforesaid document, were duly received and acknowledged by the respondent authorities on 15/1/2001.
My lord.
This is one. However, during pendency of reconstitution proposal expired.
Yes,
so 15/1/2001 is
my
it
lord.
part of the record or not?
My lord, I am sorry, my lord. This was not annexed, my lord. That's why, my lord, I have made a specific amendment in paragraph 5, my lord.
Why you have not because that shows the receipt of
yes,
acknowledgement of receipt.
Yes, yes, my lord. Inadvertently.
Is it available to you or not?
It is available, my lord. In earlier read proceeding, my lord, I have annexed, my lord, but somehow it missed out, my lord, here, my lord.
See.
I will file, I'm sorry, extremely sorry, my lord. I will file one additional affidavit.
You are seeking an interim order.
My lord, I'm sorry, my lord.
That without that, how can it be? Otherwise, it is a mere statement.
My lord.
If it has been receipt of the said application has been duly acknowledged.
My lord.
Meaning thereby,
yes, my lord.
Residue is out.
Yes, my lord.
Your father was there.
Yes.
Right?
Yes, sir.
If your father was there, then they had to consider it reconstitution.
Yes.
They kept it pending. Then during
pendency
consideration, your father died.
Yes, ma'am.
So by virtue of this thing, you should be the only one.
Yes, ma'am.
Right?
Yes.
Because with his resignation of this Rijiji,
yes,
this who is he, this man? Who made the complaint?
Wife, my lord.
Bamik?
Wife, my lord.
Is what?
Wife, my lord.
Sri Bamik. Srimati Bamik or Sri Bamik?
It should be Srimati, my lord.
So she may not have a privacy claim.
Yes. And
for,
she has also abandoned, my lord.
after from partnership with the resignation of the second partner, it became a proprietorship firm.
Yes, yes, exactly, my lord.
So proprietorship firm is identified with the proprietor only.
My lord.
Then with a date, you may have the right to seek transfer of the outlet in your name. So by the time Mamik Kamdak may not have a privacy right
My lord.
to claim partnership.
My lord, may I pray that, my lord, this matter may kindly be taken up tomorrow, my lord. I will file an
You file the
additional,
affidavit. You file the affidavit.
my lord.
Wednesday. File the affidavit by tomorrow.
My lord.
Bring on record that one.
Yes, yes. I am extremely sorry, my lord.
Heard Mr. R. Sakya, senior counsel, listed by Mr. Mr. and Mr.
BC on behalf of Tita Pak, Standing Council of Voice.
IOC.
Yes, Lord.
Okay, Mr. So-and-so, learned counsel on behalf of Mr.
Tita Pak.
T.
Tapak.
Tapak, learned standing counsel IOC for all the respond, for the respond number 1 to 4. Post of Para. By the MP order, this thing
Supply has been
supply
restored.
been stopped.
Yes.
Okay. Mr. Soikia has sought listing of the case on Wednesday in order to file an additional affidavit in order to bring a vital document on record.
Problem.
Release the case accordingly also.
Item number 8.
Made, Mr. Lordship. My lord, this case was heard extensively last week. My lord, before Mr. Navam continues his argument, I just want to bring one fact only, my lord. My lord, I have taken your lordship to Annexure 3 at page 26, my lord, which says that Group A and B should not be posted in his home district. My lord, type person is page
26.
Yes. Page,
Annexure
type
3.
is 30.
Huh?
Page, type 1 is 30.
30, yes.
Yes. 1A, my lord. No officer of Group A and B should be posted in the home district so that he does not develop vested interest. Now, my respectful submission is this post, executive engineer, is a Group B A post, and the respondent number 4, who has been at Yingkiong for the last almost 3 years, he is also from Upper Siang district. So Yingkiong, that itself violates this Annexure 3(1)A, my lord.
But basically, these policy guidelines are.
But that is only reason.
Not enforceable. These are for guidelines.
My lord, these are the guidelines. But then, my lord, with impunity, they cannot violate also. Now, my lord, secondly, my lord, if we see the affidavit of respondent number 5, the MLA, to Yingkiong MLA, he says that he has given this notes on the basis of a request made by some people. There only 20 of them are there, but if you see the documents, only 10 has signed.
You have said, but both the MLAs are from that area. They can have a voice. My anxiety is that my query would be, where is the impugn order? Page
48.
48. Now, here, for petitioner, SEPA WRD division, under order of posting at Yongkyong WRD division. That is, the previous order is at page 37. Right?
My lord.
29/10/2025.
My lord.
Now, the council for the parties are to address on the office memorandum 13/2007. Because after 29/10/2025, you
I have
You were released on
Released.
6 November 2025.
But-
So you were not in a hurry. You have, as soon as you were permitted to be released on 6 November by the superintending engineer.
engineer.
So
I proceeded to join my new place
Huh.
of posting on the same.
so page 38 is taking over charge.
Yes, handing over and taking over.
Huh. So if we read this office memorandum, come to page 45.
Madam.
As soon as seal number 2,
As soon
first,
as the
it is
transfer-
clarified that once transfer posting orders are issued by the competent authority, no further order or permission is required for the officer to join in his new place of posting. The following instructions regarding joining and relief of officer on transfer are hereby reiterated. So it was there already, but it is reiterated for clarity. As soon as the transfer orders are issued, the relieving officer will proceed and join in his place of posting without undue delay.
My lord,
So you are the relieving officer.
yes, I handed over and then
You are the relieving officer for
on the basis of 29 October
Kartik Apang. That is response number
4,
4. Okay, so you proceeded.
I proceeded.
Then next one, the relieved officer will prepare the accounts of the case, stores and other records to be handed over to the relieving officer.
My lord,
On his assumption of charge of the office, hand over the same to the relieving officer. That was his duty.
that was his.
As and when he comes to assume charge of the office. If he is on leave or something like that, absent from office, it is not the duty of the relieving officer, right?
Now,
Then
4.
the relief officer should not absent himself. Now here, he absented himself,
Himself.
by taking leave. In his affidavit, clear, loud and clear. Should not absent himself and or obstruct in any way his reliever from joining the post smoothly. Such action would be amount to misconduct or disobedience. Next 4. In cases where the relief officer does not hand over the charge of the relieving officer when he comes to join. 6th of
Yes.
November.
7th.
7th of November. He came to join. The relieving officer will assume charge of the office unilaterally or ex parte so as to implement the government's order. So from the petitioner side, he has performed as part of his memorandum.
Yes.
Right. And to enable the officer to discharge his duties and responsibility without delay. The relieved officer will stand automatically relieved once the relieving officer assumes charge of the office. A copy of the joining report and assumption of charge should be sent to the head of the department concerned, immediate controlling officer, treasury officer, and all concerned as usual. Now come back. Come to office noting. Come to office noting.
Yes, my lord. Page 52.
Page 52.
51, it starts from 50.
It starts from 51. Everything started on 30/10/2025.
My lord.
Process. Now come to page 52. In pursuance of the said orders, Mr. So-and-so has handed over the charge of EE SEPA WRD division on 4/11/2025 by certificate of transfer of charge uploaded in, I think, some portal, right?
My lord.
They are in clear knowledge of the said fact, which may kindly be seen, right? Subsequently, S.E. Zamiri has released him from SEPA on 6/11, enabling him to join his new place of posting by order dated so-and-so. Next, as per the disposition list of EE, the transfer and posting of so-and-so from SEPA has been issued before completion of his normal tenure of so-and-so. Meanwhile, so-and-so, UA note, right?
No.
So he was released. And according to this petitioner, he has joined page 40.
40.
Page on 6/11 before superintendent officer. Then he also sent a WhatsApp on 6/11. right?
Yes.
And this
Then on
page
7,
43 is
40,
dated
I have taken over the
7/11.
7/11.
Now let us see the affidavit.
Now,
1 and 2.
the page
Just a
44,
minute, just-
I have given this information to all the controlling officer, the deputy commissioner, bank, treasury officer.
Now, 1 and 3 says it is a matter, OM is a matter of record. Come to the affidavit of the respondent number 3. Sorry, 2. 2. Para 3. He said the joining letter has been handed over by the petitioner to the personal assistant of the undersigned at his official residence in Pasigat. He was also absent.
He was also absent.
Right? Till 10th of. So whatever was possible from the end of the petitioner, he had done it. If the respondents, by absenting themselves, tried to subterfuge the attempts of the petitioner. Now let us see the annexure, Mr. Navam. Then you make submission. Page 73 of this affidavit of the respondent number 2. Whose endorsement is this?
This is the superintendent engineer.
Since the incumbent has already assumed the charge, it is not necessary to issue order of handing over charge. Whose endorsement is this? Mr. Nabam?
This must be the petitioner, my lord, they
No.
received by PA to AC.
That he has acknowledged. Respondent number 2 has acknowledged. He said that I was out of station. But the fact of the matter is that it was handed over to his personal assistants. Now, who has made the endorsement? Because it is official seal also.
It must be the superintendent engineer.
That receipt number is 1196, dated 7/11/2025. O/O superintendent engineer.
His endorsement
Now
is
below, and there is an endorsement.
1911.
10/11. 10/11.
Yes.
Since the petitioner has already assumed the charge, it is not necessary to issue order of handing over of charge. Who has made this endorsement?
R2 is the superintendent engineer. Department.
Yes, Mr. Nawam.
My lord.
Who has made this endorsement?
My lord,
Because once he joined, the relief officer stands automatically released. Then, subject to your submission, definitely, my query I am putting forward.
my lord.
It is not like that. It's some judgments are there. It is not like the case of. It is there. It was there, in the file. This Pubilombi. Pubilombi was different. The fact of the Pubilombi was, in the transporter, it was specifically mentioned that you go and join in the month of April after the incumbent retires. But he's rushed he got himself relieved, rushed there to join. When the order, the incumbent was supposed to continue in the post till the end of April. So facts of Pubilombi is not similar to this case.
Except, sorry for different, except MLA notings.
MLA, I don't accept.
Facts.
MLA are, no, let my position be clear. MLA can make recommendation.
No doubt about that. Yes, if they are local representative,
They are local MLA make recommendation, right? And at the same time, if you read
that
Pubilombi,
yes, my lord.
Not Pubilombi, not for one purpose, for another purpose. MLA had made recommendation. Said, let this respond number be continued for continuation and timely execution and implementation of the schemes. All these judgments regarding recommendation of the MLA is regarding public complaints.
Right.
All these decisions are based on that I have received public complaints against this officer. Right.
Right, madam.
But here is a case, there is no whisper against the petitioner that he is suitable or unsuitable to carry out the projects. Right. Now come to Pubilombi decision. Decision. Let us have the Supreme Court view. Come to. One judgment has been quoted there. Para 9.2.
9.2, then 10.
No, 9.2. Stick to 9.2. N.K. Singh, Union of India.
Yes, my lord.
Para 9 of the judgment has been quoted.
Yes, my lord.
Before that, Para 9.2, let us read. Court further curtailed the scope of judicial review in the case of N.K. Singh, holding that the person challenging the transfer ought to prove on facts that such transfer is prejudicial to public interest. It was further reiterated that interference is only justified in a case of mala fide or infraction of any professed norm or principle. Now, your office memorandum is professed norm, right? Moreover, in cases where the career prospects of a person challenging transfer remain unaffected, neither of the petitioner or respondent 4 career prospect is unaffected. They are same. They are same. And no detriment is caused. Interference to the transfer must be eschewed. It is further held that the evidence requires to prove that such transfer is prejudicial, and in absence thereof, interference is not warranted. Law reiterated by this court is reproduced. Now this one, this paragraph. Transfer of a public servant from a significant post can be prejudicial to public interest only if the transfer was avoidable and the successor is not suitable for the post. Right? Suitability is a matter for objective assessment by the hierarchical superior in administration. To introduce and rely on the element of prejudice to public interest as a vitiating factor of the transfer of a public servant, it must be first pleaded and proved that the replacement was by a person not suitable for the important post and the transfer was avoidable. Unless this is pleaded and proved that a threshold, no further inquiry into this aspect is necessary and its absence is sufficient to exclude the factor from the consideration as a vitiating factor in the impugned transfer. Now, there is nothing. It goes both ways. It is not only from the petitioner. It is also applicable for a state. His successor is unsuitable. There is nothing. Nothing.
My lord, suitable here, my lord, if your lordship peruse, my lord, the MLA.
MLA's view.
MLA
is not the view.
No, my lord.
Now tell me,
My lord, as a public.
tell me whether by joining in that manner,
My lord.
after being released, Pubilambi is that without waiting for release, the man went out of his original place of posting to rush there.
My lord.
And both of them were under orders of posting. There was nothing like this. Now here is a case. This man, after being duly released, joined as per your office memorandum procedure.
Correct, my lord.
Right? Superintendent engineer received it. Then transfer of posting as per office memorandum was taken unilaterally. As soon as it is done, the relief officer stands relieved.
My lord.
Your norm. I am not setting my norms.
My lord, in that point, I will like to deviate little bit, my lord, because joining, my lord, and assuming, my lord, there are some standard procedures, my lord. Your lordship is aware, my lord.
This is office memorandum.
Yes, my lord. Now, my lord, in that office memorandum, my lord, it has not been mentioned, my lord, there is a controlling officer. The moment someone released, he has to report there, my lord.
No, that has been done away with.
My lord, no,
That has been done away with.
I'm not talking about the WhatsApp that university.
No.
My lord.
It is clarified that once transfer posting orders are issued by the competent authority,
correct, my lord.
No further order permission is required for the officer to join in his new place of posting. It is your norm.
My lord, I'm sorry.
And this is for clarity.
My lord. Now, my lord, practically, my lord. If
practical will not do.
My lord, here also, my lord, it says, my lord, if your lordship see, my lord, this.
If you profess to go by a certain norms laid down, then you are bound to.
My lord, your lordship must be bothering with the paragraph 4, my lord. Am I correct,
Yes.
my lord? Paragraph 4. But before paragraph 4, there are certain things to be exercised, my lord.
Yes.
Certain things to be exercised, my lord.
Yes,
He
the
has-
relief officer should
No,
prepare the accounts.
that is second stage. First, my lord, he has to report.
Oh, one interesting comment. I remember.
My lord.
One interesting, 1 minute, 1 minute. Mr. Tapu is benevolent in saying that
In his affidavit, my lord.
the modification order, that is impugned order, neither expresses nor implies incapability or inefficiency of the petitioner.
My lord,
He has also acknowledged efficiency and capability of the petitioner.
my lord, generally, my lord, in transparent posting, my lord, these are not, my lord, neither, my lord, in written or is whisper in there, my lord, whether he is suitable, unsuitable, or not, these things, my lord. My lord,
From the standpoint I am saying, it is nowhere that the petitioner is incapable of executing.
my lord, correct, my lord.
Let me, I am saying about the fact, existence of facts. Nowhere it is said, no whisper is made that the petitioner is incapable to carry on the execution
My lord.
and implementation of the schemes.
Correct, my lord.
Right?
Right, my lord.
Nobody, neither the state. In fact, Mr. Tapu has, in express words, said,
My lord.
no inefficiency, no incapability of the petitioner. Right?
Perhaps that will, my lord, that will indicate to both, my lord.
No. He says petitioner. No. Cannot be perhaps. Petitioner, he says. Right. The modification order does not express any inefficiency, incapability of the petitioner. Right. He has not praised himself. He has praised the petitioner. Now, tell me.
No, my lord. My lord, as per this office memorandum, my lord, this is the, my lord, second stage. First, my lord, once a transfer officer is transferred, my lord, to any place, there must be controlling officer, my lord. The first and primary duty of a transferring officer is to report to that controlling officer. Look, based on this transfer order, I will release from my established so that I could join here. This is my joining report. He has to submit. On the joining report, my lord, the controlling officer will, my lord, further write the another, my lord, the relief officer to hand over the charge. But this is the standard procedure, my lord.
Right.
Established
Right.
practice as on date, my lord.
Absolutely correct.
My lord. Now, what happened in this case, my lord? The controlling officer are absent for just 1 day, my lord.
No.
10th, my lord.
4 or 5 days.
My lord, as per the affidavit,
He reported on 6th of
3 days.
3
All
days.
right, my lord. Now,
And respond number 4, he absented himself 4 days.
my lord, now,
So,
my lord, agreed, my lord, the controlling officer remained absent for 4 days. My
but it was delivered to him,
Deliver in what fashion, my lord?
the joining letter.
That's why I said, not in WhatsApp University, my lord.
No,
My lord,
not in WhatsApp.
my lord,
No, I am not in WhatsApp University.
my lord,
I am saying
one
that-
cannot, my lord, submit his journal report in WhatsApp, my lord.
No, it is not WhatsApp, sir. Not in WhatsApp.
My lord,
Leave aside WhatsApp.
my lord. Now, my lord, rest, my lord. Now, my lord,
Whether, that is the question, as per your office memorandum, whether, my question is clear. Whether, as per the office memorandum, these are for clarification, meaning thereby, this was in existence, this procedure was in existence
my lord.
from a prior date.
Correct.
It has been issued only for clarification.
Correct, my lord.
And these are quite clear.
My lord,
If,
yes,
if 3 is not possible, it is 4.
correct, my lord. Correct, my lord.
Now, here is the case. Everything is to be with promptitude. Now, these 2 men absented themselves for 4 days. Now, petitioner had joined. It is not that on 29/10/2025 he had hurried. He waited till his release.
My lord, before release, he can't join also, my lord. You
No,
must
it is
kindly
not
note, my
there.
lord.
Not necessary. Mr. Navam,
No.
you cannot make submission against your office memorandum.
No, my lord. First one has to release.
No, not required.
I'm sorry.
Read again.
Your lordship is referring to, my lord, office memorandum, right, my lord?
Yes, page 45. Read again. Government has to speak in one voice, so additional advocate general is to speak in the same voice.
My lord, may I just read, my lord, for my clarity, my lord?
Yes, for your clarity, for all clarity.
My lord,
Page 45.
page 45, my lord,
First para.
first para, my lord. A government servant hold office at the pleasure of the, this is may not be that important, my lord.
Next. Government
next.
issues orders.
Yes, my lord.
Government issues orders.
The government issues order regarding transfer and posting of officer from time to time as per administrative requirement. It is clarified that once transfer and posting orders are issued, by the
No further order
no further
or permission.
require for officer to join his new place of posting.
So where is the
The
control
following
officer?
instruction, your lordship make a require for officer to join his new place of posting. No further order is required.
Permission also.
My lord, but so much to give report, my lord. At least, look, I have joined my duties as a so and so much to give the report, my lord.
Who? I
My
don't know. Your office memorandum.
My lord.
Then next,
But
please read to.
my lord.
Read
My lord,
to.
as soon as transparent posting will join his new place of posting without undue delay. No doubt about that, my lord.
When competent authority passes, I
My
mean,
lord.
he is the secretary.
Suppose
Secretary of the department for, say, assistant engineer,
look,
executive engineer.
but your lordship may kindly bear for 1 minute. Suppose secretary issues, my lord. Mr. X transfer from Itanagar so and so. My lord, the secretary will not, my lord, issued further order that he should join here and there on.
But your submission is satisfied here.
My lord, now, my lord,
Look at
in
page,
every district there is a controlling officer, my lord.
Look at page.
Your lordship referring to which page, my lord?
Just a minute. Look at page 39.
39 of the petition, my lord.
Hmm.
My lord, may I read, my lord? This is order dated 6 November 2025. Order, my lord. In person of government order number so and so that the 29 October 2025, Sri Vienong Pertin, Executive Engineer Water Resource Division SEPA is hereby released from his establishment today on 6 November 2025, enable him to join his new place of posting as Executive Engineer. Minor joining, my lord. So joining has to be given.
First you said, your submission was that you have to be released. This has been released.
Yes, my lord.
Ah.
After release only, my lord, he can go to new place and join there.
Yes,
My lord.
yes.
Yes, my lord.
Yes. Thereafter, everything is without undue delay, right?
Correct, my lord.
He went there. How much is the distance?
Around 5 to 6 or maybe, my lord.
So it is possible to reach.
One day, my lord, may not be, my lord, may not be. 600, if it is 600 kilometer, one day, my lord, it is not possible, I think. Even, my lord, good motor road also, my lord.
Okay.
Now, what I was, my lord, try to make the point, my lord. Now, my lord, before doing all these things, my lord, he has to join, my lord. Submit a report that based on this transfer order, today I am, my lord, joining as an executive engineer. After that, he can take charge, my lord. Now, my lord.
That is 3.
That is 3, my lord.
Para 3.
Correct, my lord.
Para 3.
Now, my lord.
Now, if they do the finishing act, your controlling officer do the finishing act, right, for 4 days, and Mr. Tafu also does the finishing act for 4 days. What is the option available that has been given in Para 4?
That has been, my lord.
Para 4?
Yes, my lord. Para 4, provided, my lord, the control officer.
But still, he had done it, informed
the controlling officer.
Yes.
Others, my lord.
Yes, but they have done the finishing act.
But even that, my lord, now, is there any embargo, my lord, to the authority not making any further?
That is what I am saying.
My lord.
My question is that, not MLA or all. Come to page 48.
48, my lord.
The transfer order was in Pubi Lambi, both were under orders of transfer. Nobody had joined. By that time, modification orders came. And in that context, division bench, single bench, Supreme Court, whatever has been observed, I have read. Now here, with this completion of formalities by the petitioner, this man stands relieved.
Correct, my lord.
Allegedly.
Yes, my lord.
Then how can both be under orders of transfer? This order should have been the petitioner is transferred from Yongkyong to somewhere else. Again to SEPA or Daporijo, whatever. From Yongkyong to Daporijo.
Exactly, my lord. But he only says that under order of transfer.
No, it is not under order of transfer. I have read Pubi Lambi. Single judge, division bench, Supreme Court. I have read. There was specific order, don't go before April. But the respondent of 5 in Pubi Lambi, he went there to join in April, prior to the date of the relieved officers' retirement or superannuation. That post was not vacant.
My lord.
Right, but MLA was also there in Pubi Lambi.
Yes, my lord, he was there.
But the fact of the case is different. It was interfered on that basis. Yes, MLA, that Masood or what?
Muhammad Masood, my lord.
Same thing. They can make representation. Here the question is whether this transfer order has been walked out or not, 2019-2025. This is my concern.
My lord. Then second, my lord, I put myself, my lord. Is there any restriction or, my lord, embargo upon the authority?
No.
Not to transfer him again.
But this is wrong.
My lord. Then you lordship may kindly see.
I'm not saying that it has any embargo. a person cannot be transferred
my lord.
just because he has not completed the normal tenure for administrative purposes, exigency of service, in the interest of public service, and conspicuously, this order is not in the interest of public service.
My lord,
Come to page 48.
my lord, before this page,
Is there any mention?
before
Is there any mention in the interest of public service, sir? Impugn order.
My lord, yes, I'll be answering to that. Your lordship may, before my lord 48, your lordship may kindly see my 37, my lord. Is there what any public interest is there or not, my lord?
It was there.
Then, my lord, the 40 is in continuation, my lord.
No, it has been worked out. That is
But
what.
if the public interest is not mentioned, it is in continuation to the original order, my lord. Your lordship may kindly note that.
I am noting it. That is why I am noting it. That is why I am putting it.
Then another important things, my lord.
But if you are making submission against this OM,
my lord,
and here that says that it is a matter of record. The state have said, the state respondents have said that this office memorandum is a matter of record.
Matter of record, my lord.
It is a matter of record.
My lord, the law has been laid down. Your lordship is very much aware, my lord. Regarding all these things, my lord.
Proceed on basis that I am not aware.
Then, my lord, then let me reiterate again, my lord. Page 37, the original transfer order, my lord. Your lordship, in public interest, your lordship may kindly note 3 persons. Has your lordship got it, my lord?
Yes.
Number 1 is Mr. Hanu Techi. Number 2 is the petitioner, my lord, Gegong Parting. Number 4, Apang, is the respondent 4. Then in partial modification, your lordship find only 2 figures, my lord. The petitioner and the respondent. 1 person is missing, my lord, because he already joined there. Right, my lord? Now, after this, my lord. Your lordship may kindly see the remark column, my lord, serial number 2. By Siri Hanu Techi Tara A transferred. So, Daporijo, there was a vacancy, my lord. There was a vacancy.
Three-way musical chair.
Yes, my lord.
Three-way musical chair. You read Hanu Techi Tara. He was from Daporijo to Sepa.
Correct, my lord.
Petitioner Sepa to Yongkyong. And respondent for Yongkyong to Daporijo. It was three-way affairs.
Correct.
Right? Interchange. That's all.
My lord.
Only these three. This man, Hanu Techi Tara, petitioner got released. He joined.
My lord.
Petitioner reported in Yongkyong. Then the game was played of Vanishing Act. He joined as part of following the office memorandum. If we go by the office memorandum, as soon as he joined unilaterally, this man stands relieved. Stands released means what he was doing till 9th of October, 10th of November. He was without post. Respondent number 4. How can he be on order of transfer? I am in the technicality of the order.
My lord.
I am not saying that the state does not have the power to transfer in violation of the policy guidelines. Right?
Right, my lord.
They can, for proper reason, they can affect transfers.
My lord.
Be it within, say, 2 years, 3 transfers. If requirement is there, there should be transfer.
My lord.
Right. But question is that whether it has, that order 2019-2025 has been worked out or not. If it is worked out, then this should have been worded differently.
My lord. Now, my lord, if you this 29, whether it is worked out or not, my lord. My lord. In compliance, my lord, there is no dispute about that. The petitioner may join there. He went there, my lord.
And your stand in the affidavits also,
my lord,
support them.
My lord, I am not disputing that. He went there, my lord, although, my lord, on that relevant time, the controlling officer was not there, but he has submitted his joining report. No doubt about that, my lord.
Let us see what he says, this respondent number 5 also. 4. He says, answering respondent was on station leave from 4/11/2026. The deponent was absent on 6/11/2025 on station leave. That is his statement, right? And the statement of the respondent number 2, that controlling officer, your so-called controlling officer perhaps. Is it not? Is a controlling officer?
Executive file क्या है?
He says, petitioner submits his joining letter as executive engineer Yongkyong addressed to the undersigned on same day. Letter being partially handed over by the petitioner to the personal assistant of the undersigned after the officers in the official residence in Pasighat. And this has been officially acknowledged.
Well, that's why, my lord, since beginning, my lord, I have not disputed, my lord, joining all these things. My
And come to
7 soft copies, 2 letters bearing number so and so were also provided by petition through WhatsApp. That's the context of this.
And he also acknowledged receipt of the joining letter in WhatsApp also.
Well, yes.
Yes. Then assumption of charge expertise of the office of the so-and-so. Then, however, the office of the undersigned is yet to receive the hard copy of this letter till date. How can he say that's in endorsement? I have taken you to an endorsement, right? That page 73. Whose endorsement is this?
This letter.
This has been officially acknowledged to have been received by number 1196 dated 7/11/2025. It is his seal signature.
This is the same letter which I have annexed.
Yes.
40.
Now it has received.
He's received it, then later on it's endorsed.
My lord, I'm not disputing, my lord.
7/11.
I'm not disputing.
Now your office note and these recommendations are subsequent to
This is 10/11, my lord.
working out of the transfer order. See, process, how the applications were processed. Page 52. Page 51. It was being processed.
My lord, it was processed on.
Now, but process, yes. If you succumb to the request of the MLA also, that petitioner has to be from Yongkyong to somewhere else. You have to rebut my query. Not from under order of transfer. You can do it.
My lord.
On the basis of if you succumb to the pressure because he is personally known. Yeah, respondent number 4 is personally known to the respondent number 6. Maybe a friend of his.
My lord.
So he may want to retain him despite 3 years of tenure. He has admitted.
My lord, not necessary, my lord. Partially known means.
I am not imputing anything.
Not this a negativity, my lord. My lord. Partially. Why, my lord, he says he's a local MLA, my lord? When someone's local MLA.
I'll not go to that, Mr. Everybody signed without any whisper. Everybody has signed in the official file without any whisper. Right?
Well, that's why I say I was.
Not a single thing.
No comment.
Even no comment is not there. No comment also indicates that, yes, he has applied his mind. And thereafter, he has found that himself that no comment is required. There is nothing.
My lord.
Everybody? Yes, sir.
My lord, your lordship said, personally, I know him. My lord,
I am not putting it that.
My lord, that cannot, my lord.
I am saying it sarcastically.
I understood, my lord. I understood, my lord. My lord, may call in that. They are the.
It do not go into that.
They are the local MLAs, my lord. My lord, they knows, my lord.
I know.
My lord. Now, my lord.
No, I am not into that.
Now,
they may want to retain the respondent number 4
my lord.
at Yongkyong. I'm not into that.
my lord.
I'm into the procedure which has been laid down by your state. How a transfer order is to be affected, worked out, and materialized. Right? By the time this impugn transfer order was issued on 10th November 2025,
Correct, my lord.
the transfer order dated 29/10/2025 was worked out. Meaning thereby, nobody is under order of transfer, order of posting.
My lord.
That is what I am
My-
on.
I understood, my lord. Your lordship mean to say, my lord, the impugn transfer order already culminated, my lord, the moment, my lord, the petitioner assumed the duty, my lord. Right, my lord?
No, this man also stands relieved.
Correct, my lord. My lord, correct, my lord. Now, my lord, I put myself, my lord, after doing all this exercise, my lord, can, my lord, we can still transfer him in public interest, my lord?
No,
Or in
you can
in-
transfer him,
my lord.
but this is not the way.
Yes, my lord. Now, my lord, the MLA notings, my lord.
After the order of the court, suppose you can transfer him again. That is not the issue.
My lord, now law, now, my lord, law has been settled, my lord.
Law has been settled. I am
My
within
lord,
the contours.
Mr. It says, my lord.
I am not making any comment as regards the power of the MLA
My lord.
to submit UO notes.
My
I am not into that.
Now, my lord, the another angle we have said, we have to see, my lord. Suppose retaining the private respondent, my lord, for some time, my lord, is not permanent, my lord. No one can say that I should be, so long I remains in the service, I should be in
I will not make any
Mal-
comment.
Correct, my lord. Now, my lord, even the private respondent cannot be retained permanently there. Suppose we make a temporary arrangement. Suppose in continuation we say,
No, make appreciation about him.
My lord.
Bring him,
My
bring him to Yongyong again.
why
Bring him, make appreciation of his laudable works.
I
Then
why-
his presence is required. Give reasons.
my lord, reasons,
Bring him on to Yongyong.
reasons, my lord, there is reflected in the file notings, my lord.
But where is
my lord,
that?
some project is going on.
Where is that, sir? Where is that?
My lord, page 52, my lord.
Yes.
1 to 3rd paragraph, man. Meanwhile, my lord, both MLAs of the area has submitted a
They have submitted.
my lord.
You have not acknowledged.
They have submitted, my lord, perhaps, my lord, the authority they have examined it, my lord.
Sir, if you want, their water resources department, right?
Yes, my lord, Water Resource Department.
What kind of, if you want me to make more scathing, then let us see the works. If you want to take me to the works,
My lord,
Right.
I'm not saying, my lord, the incumbent
No,
is
no, no, no.
incompetent. I'm not saying that.
what
Your
water
Lordship,
resources?
Let me clarify myself, my lord.
What they are PWD engineers or what?
My lord, they are, my lord, civil engineers, my lord.
Civil engineers.
Departments are different, my lord. They are water work department. my
What they
lord.
have the water resources,
Water
I
resources.
can know flood control measures,
Flood control and
embankment, river, this thing,
flood control,
irrigation,
like
irrigation.
these things, my lord.
What they have to do with semi-RCC cum store for agriculture development officer, integrated 10-bedded Ayush hospital.
My lord, that's for water supply, my lord. My lord,
Only water supply.
my lord, for irrigation, for medical, my lord, there has to be storage, my lord. Obviously, my lord. Without any storage of water, my lord, from
Oh, only the pipes.
no,
Plumbers.
no, there has to be constructed.
Plumbing work.
My lord, tanki has to be constructed, my lord.
Oh, tanki, that is for
Now, that's why, my lord, I'm saying I'm very careful with my word. I'm not saying,
construction
my
of
lord, the
kitchen,
I'm not saying
construction of kitchen and dining hall. Right. Construction of type 4 quarter. They have to be busy with rivers, dams, irrigation projects. Right. They are 8 units of staff quarter. What kind of big projects they are involved? If you want to say these are, then I'll make record of every project they have identified. These MLAs have identified. See the projects. Kitchen hall?
Kitchen hall.
Kitchen hall? I'll not say much, Mr. Nabam. What kind of they have identified? Let us see. Response number 6. Kitchen and dining hall for boys and girls hostel. Type 5 quarter for principal. Construction of boundary wall around girls. Their water resources department expertise is required for construction of boundary walls around girls hostel. They have identified these projects, these MLH, for his retention. Still, I am not making any comment. But if you want to put me into that, if you want to take me to that, then I have to make this. Response number 5, 1 minute. What kind of?
Paragraph 8, madam.
Paragraph 8. Paragraph 8. Establishment of integrated 10-bedded Ayush hospital, same.
My lord,
35-seater hostel building for working women. Construction of girls hostel. What kind of water resources expertise
My
required?
lord, I'm sorry, I don't have that copy, my lord.
You? Yes.
Now, my lord, within 1-2 minutes, I'll sum up my argument, my lord.
Yes, please.
Now, my lord, as held in SL Abbas, my lord. Now, my lord, in transparent posting, under what circumstances, my lord, the court should interfere, my lord. Now, my lord, here is the case, my lord. My lord, there is no any violation of, my lord, statutory rules, my lord.
No.
My lord.
No.
Neither, my lord, they say, my lord, there is any malafide allegation, my lord. What they are
No.
exactly saying, my lord, that.
That is also not absent.
My lord. Then, my lord, that under that circumstances, my lord. Now, my lord, these guidelines, then my MLO noting that law has been already laid down, my lord.
That is that was processed, right?
Correct, my lord. I'm not denying.
That was after both the MLAs have recommended after the order dated 29/10/2025.
Correct, my lord.
Admittedly, on 30/10 and 31/10.
My lord.
Then that was processed from 7/11. 7/11. And the order was issued on 10/11.
10/11, correct, my lord.
After being processed, having received signatures of all the competent authorities.
My lord, your lordship may kindly note, my lord, when, my lord, this file was processed. When
7/11.
I'm sorry, my lord.
7/11.
7/11. Then petitioner was released on 6th, my lord.
6th.
Distance is more than 700 kilometers, my lord. Is it possible, my lord, he'll be joining the
superintendent engineer acknowledge it.
The acknowledgement is 10, my lord, 10th.
No, he said on 6th. He said on 6th, it was delivered to him on 6th.
My lord.
In the affidavit.
Deliver, my lord, that's my lord.
On 6th.
My lord, through WhatsApp, my lord, maybe, my lord.
Maybe by helicopter, I don't know. That I am not concerned. I am not concerned. It may be by helicopter also. I don't know.
So one thing is very.
He said on the same day, letter was personally handed over by the petitioner to the personal assistant.
On the same day, Miss 10th, my lord, or
6th.
6th. That is not possible. There must be something wrong, my lord.
No.
Your lordship may kindly note my release
You
order.
need evidence for that.
My lord, your lordship may kindly see the release order, my lord.
No, see the endorsement of the
superintendent engineer, my lord.
No.
Or
see page. You just see the page.
73.
Page
73. This was officially acknowledged on 7/11/2025 by receipt number 1196. Is it not? Is it not? Page 73?
I'm not disputing that.
Then,
my lord, what I am trying to make a point, my lord. Now, petitioner release on 6th, my lord. Your lordship may see that this thing is more than 600 kilometers.
I'll not.
My lord, now, my lord, while putting, my lord, the date maybe there may be some
If,
human error, my lord.
it is, maybe this has been drafted by Mr. Nabam only.
My lord, one thing is very clear, my lord.
Affidavit is drafted by
Mr. Nabam.
Nabam only.
My lord,
So
I'll
you
not.
cannot
but-
vary it
No, but one
from
thing,
the statement made on oath by the respondent number 2.
my lord. But one thing is very clear, my lord. Before,
You
my
have said that how can it be possible?
lord. But one thing is very clear. Lordship may
You
kindly,
have yourself endorse all of
Lordship may kindly appreciate, my lord. When the file noting was moved, when the file process was initiated,
file.
when he assumed the duty, my lord.
Recommendations were received on maybe 38, but ultimately it got finalized on 9 or 10.
9 or 10, my lord. That means, my lord,
By that time, as
not,
per your office memorandum procedure,
my lord.
everything was complete. This man did not join. It is his personal conduct.
No, my lord.
But he was released.
My lord. Correct, my lord. He was released on 6, my lord. No doubt about
And
that, my lord.
two men cannot function.
In one place, correct.
That is also there.
Correct, my lord.
So it is his option not to join at his depot rejo. It is his, but he was hanging, meaning thereby he was hanging. So it cannot be, I am into the impugn order. This is not under order of posting. This has been materialized, walked out, 29/10/2025. This, the manner in which this impugn order has been passed, that is what I am saying. Not with regard to all the settled position of law. It is an acknowledged fact that an employee can be transferred from any place to any place for administrative exigency
my lord.
in the interest of public service. And it is not to be interfered unless it is mala fide, which is not the case here. In violation of any statutory rules, it is also not the case here. Infraction of some profess norms, it is here. There are several judgments on profess norms also, right? But even after that, suppose if I hold it, it has been worked out. Even after that, right is available to the employer. If this man is required for construction of kitchen in boys' hostel, boundary wall, you can still take him back. No issue. Because his expertise is maybe not in dams or river project, maybe in expertise is in construction of boundary walls, kitchens. So you may retain him at the Yonkyong.
My lord, for the timing, my lord, just keep aside this MLS, my lord, that scheme only things, my lord. Now, my lord, your lordship,
They have not identified any project, public project. These are public projects. But
Yes.
boundary wall in a girls' hostel, 35 bedded hospital,
hospitals.
and a kitchen in a boys' hostel and girls' hostel. These are plumbing works. Plumber can do it. Even Mr. Patin is placed there, he will complete this task.
My lord,
But
he is
if it
master
is
of all, my lord.
river project or something like that, yes, very important. He is in the thick of things. I can understand.
My lord.
And it is not that any whisper, any complaint against this man.
Well, sometime, my
Though the projects that has been identified is too
maybe, my lord.
small.
Yes. My lord, sometimes there may not be any complaint against any my lord, officers, my lord. My lord, even then, in exigency of any my lord, public
No,
interest,
I don't
we can do that, my lord.
dispute
Now,
that position.
my lord. Now, my lord, Mayor, my lord, there is a 2 MLA notes, my lord. That cannot, my lord.
I
authority
also
be
do
a-
not dispute that.
Yes, my lord.
I also do not. I go by you.
My lord. Then, my lord,
But the time when the impugn order is passed, that
My
is
lord.
material.
My lord, time if your lordship
If we
see,
go by your office memorandum,
my lord,
which has been issued for clarity,
my lord.
and clarity, it is clear. Everything was done by him. He was not in a hurry also. Only after being released, he went there. Now, whether it was possible for him to travel that distance, that it is not for me to say.
My lord, your lordship may kindly see the my lord hurriness or my lord.
No hurriness.
Not. My lord, he was released on 6, my lord. He is shown, my lord,
Some judgments are placed here by different councils, right? Maybe by the petitioner or maybe by the respondent.
both sides.
There also, Mr. So-and-so, this office memorandum 13 to 2017 was taken, right? So there something was, hurried manner was discussed.
Well, if I recall myself correctly, my lord, during that interim order, I also raised this question. Is it possible, my lord, humanly that covering my lord 700 kilometers, next day he can join there, my lord? Because Pasigat here to Pasigat, then those places, my lord.
If that is the question, I will say yes, it's possible.
Possible. My lord, with chopper service and other, my lord, yes, it may be possible, my lord.
Possible. Nowadays, everything is possible.
Possible, my lord. Correct, my lord.
Okay.
Now, well, my lord, the passing the impugn orders, my lord. Only the things, my lord, I ask myself, my lord, whether
Therefore, interim is quite. You have referred to Masood
yes, madam.
Ahmed,
Yes, madam.
right?
Correct, my lord.
You have said guidelines should not come in the way.
No.
The tenure would not be
That Masood
enforceable.
will be, my lord, regarding my lord.
Then you refer to Pubi Lombi. Pubi Lombi. No allegation of malafide.
My lord.
Then you have said Michi Nibo. Michi Nibo. Michi Nibo you have referred to. Oh,
no.
Mr. Tapu has referred to.
My lord. My lord.
Mr. Tapu has referred to. There. That is regarding tenure, perhaps. Masood Ahmed was referred to in.
Muhammad Masood Ahmed is pertaining to my lord, MLA notice, my lord. MLA notes. Then I refer my lord, Poonam Burma, my lord, that Delhi Development Administration, that is
Poonam Burma.
Yes, my lord. That is pertaining to guidelines, my lord. Then SL Ambas, my lord, under what circumstances, my lord?
Poonam Burma I don't have, but the guidelines, transfer guidelines, this is regarding tenure.
Tenure, my lord.
That
my lord.
I would go by your position
My lord.
that transfer guidelines are not enforceable.
Correct.
This is to be followed to the extent possible, otherwise it is not enforceable. The petitioner cannot enforce.
My lord.
In a petition under Article 226. But what about this office memorandum?
Well, office memorandum, guidelines, my lord.
No, office memorandum is process norms. And these are for clarity. So this is
clarity based on guidelines, my lord. You must make a note, my lord.
This is transfer. If you refer to this thing, you have financial rules in Arunachal Pradesh.
We don't have financial and rules, my lord. We follow, my lord, central, my lord.
What is the central position regarding joining?
Joining my lord,
Concept of unilateral joining is always there.
my lord,
Concept of unilateral joining is there or not?
mm, in
It will be there.
unilateral, yes, it's there.
It will be there. Concept of unilateral joining is not foreign.
It's not foreign, provided there are certain, my lord, norms.
What norms? Norms
Well,
you have given.
Norms, my lord, here, my lord,
Mr. Rotan is, Nabam is making any deviation, any different submission from this office memorandum?
no, my lord. My lord, here it says, my lord, after joining, my lord, the course of action, my lord. Lord, may kindly see once again, my lord, this office memorandum.
Please.
Guidelines. After those two,
45.
45 years, my lord. My lord, subject is says, my lord, joining and relief and transfer of charges of the officer on transfer certain clarification issue, my lord. My lord, joining and relief officer, my lord. So first, my lord, he has to join, my lord. Okay, correct, my lord. Now, where to join, my lord? There must be a controlling officer, my lord. The controlling officer is the superintendent, my lord. Right, my lord? He has to give his joining report to the superintendent engineers, my lord. After this, my lord, the following consequences follows, my lord.
That has been done.
My lord.
On 7/11, you have officially acknowledged giving an issue number.
7/11,
number.
correct, my lord. 7/11, you'll also find 7/11, then 10. The superintendent engineer acknowledged two things, my lord.
Once it is acknowledged, then after that has he has joined on 7/11 thereafter, transfer of handing over charge unilaterally. Once it is done, he will assume the charge as per your office memorandum. And as assumption of charge, the relieved officer will stand automatically relieved once the relieving officer assumes charge of the office.
But here, my lord, things little bit went perverse, my lord. Why I'm saying, my lord, generally what happens, my lord, the control officer directs, my lord, to hand over the charge. But here, my lord, before that any could be done, my lord, he has only ex parte assumed, my lord. That's why perhaps because of that only, the superintendent says, my lord. Paragraphs 4, my lord. In case where the relieved officer does not hand over the charge, my lord. Because superintendent engineer will be writing him to hand over the charge. If he does not follow, then, my lord, he can, my lord, as per the provision of 4, my lord, he can act it upon, my lord. That exactly I want to make the point. And here, my lord, he, before doing anything, my lord, he already ex parte assumed the charges, my lord.
This man was stationed in leave.
Controlling officer.
And station leave. No, the respondent 4. On 6/11, he was station leave from 4/11. He did not disclose up to what time he was on station leave. And this man was leave out of station till 10th. Till 10th.
The
controlling
officer, my lord.
Controlling officer.
My lord.
So, if they are in vanishing act for valid reason or otherwise, what is the option? This relieving officer should not be in limbo.
Absolutely no.
That is why this office memorandum has provided for the procedure.
My lord.
If everybody is absent, if both of them suppose a situation, later extreme situation, they have taken station leave for and as well as earn leave for 1 month. What will he do? He'll limbo.
But I could appreciate the petitioner, my lord, intimating to the control officer, look, my lord, relieving officer is my lord, absent, he is not handing over the charge. Kindly allow me to take ex parte, my lord.
That is not the,
That,
please issue a clarification, one more.
my lord, that
One
generally,
more clarification. In continuation of the office memorandum, issue one more clarification, office memorandum.
that's why, my lord, I've said, my lord, the generally, my lord, this is the condition, my lord, that
But that is not provided for in letter and spirit.
letter, but that is the
In the office
practicing-
memorandum, it is
that
not
is the
provided.
practicing norms, my lord. My lord, other side will also agree with me, my lord.
No, Mr. Nawam, in everyday life, this is the what for litigation, what happens? This is the normal procedure, we are doing it. But when it comes to the point of litigation, then the procedure, everybody looks into the procedure. Laid down procedure.
Yes, my lord. Sometimes, my lord, my understanding in greater public interest, my lord, hyper technical things should be sometime, my lord, it should be ignored if it in the, my lord, realm of greater public interest, my lord. And, my lord,
How can we read that? It should be laying down new norms by the court. Beyond the professed norm, you have laid down after definitely due deliberation, this office memorandum has been issued, right? By something, we cannot inject something more on the basis of submission of the additional advocate general that this is the practical situation. So if we inject something more, it will be writing the norms by the court, which is not.
my lord, there must be some duty cast upon the petitioner also, my lord. My lord, here, my lord, your lordship said the petitioner went there, and because of, my lord, the controlling officer absent, the relieving officer remained absent, my lord, then automatically he assumed the charge automatically, my lord. If this being be permitted, my lord.
But he has at least has the courtesy to submit it by going the extra mile to the personal assistant of the controlling officer, handed over personally. He has acknowledged, the letter was acknowledged officially. Then he has issued the certificate of taking over charge. Let us see that.
Then you
let us see that on 7/11.
My lord.
7/11, right? And pays perhaps 70, something like that.
7/11. 70 on it.
And everybody.
Page 42, my lord, I have sent a personal message also. As for number 4, that I'm coming.
Joining report.
आपका joining report का है?
Joining report on 7/11. What more he can do? What more he can do?
Mala, joining is all right, Malan. I'm not disputing that, Malan. Joining is all right. After joining, my lord, he has to assume the duty. Correct, my lord? If, my lord, the private respondent not handing over the charge, my lord, after joining, my lord, his duty to assume the duty as a
then forceful entry into the office.
My lord, then at least he could
forceful
have,
entry.
my lord, at least as a.
But he has run the courtesy that not to do it.
My lord, he did it, my lord. Here, he did it, my lord. Ex parte, my lord. He did it. Petitioner, my lord.
Your government has provided for.
But there are certain professional norms, my lord, he has to comply with, my lord. So that's
what?
My lord, at least.
Where is that? Office memorandum says this much only.
At least, my lord, intimating the control.
Show us some tangible document that these are required. These more are required. Show us.
Well, these are the common practice, my lord, may not be expressly either notified or in the thing.
Then in the court of law, only what is laid down, that will hold water.
My lord.
You know very well.
But only I was asking, my lord, after that, after joining report, is he submitted to the any competent authority? Look, the private respondent not handing over the charge, so I am going to take ex parte in compliance of the government notification. That's all.
When it is an admitted fact, it is also an admitted fact Both of them were not there. Neither the
Controlling officer, not the relief.
it is an admitted fact. What more? When it is an admitted fact, it need not be proved. They were already
Correct,
out. They were already out.
Out, my lord.
And the superintendent engineer of his place, he has communicated to the superintendent engineer of the other place.
Correct, my lord. He has communicated the joining report. My question of suppose after joining
Something
report,
which is within the power of a person, he can do. Suppose giving of a letter or doing a particular thing from one side, he can do. The other side, if he do, which is not within his control, either the respondent number 4 or the respondent number 2, they are not his subordinates, right? That he can order them, come back from your station. It is not that possible.
correct. My only apprehension is that, my lord, this should not be a precedence. Otherwise, what will happen, my lord? Everybody will, my lord, before joining, they'll take the expertise duty and they'll start functioning, my lord. That is my apprehension, my lord.
But you
There are-
change the office memorandum. You advise for changing of the office memorandum.
But this has been practicing for since, my lord.
Then-
There's a controlling officer,
then-
they'll submit the joining report to them, then controlling officer will write.
Add more some addendum to it. Yes, Mr. Tapu.
My lord, in this matter, it has been portrayed as if I am the villain.
No, I am not saying you as a
No.
villain.
My lord,
Absolutely not.
your lordship,
I am into the procedure only.
lordship,
I am neither casting aspersion on you or not casting aspersion on petitioner. I have said the MLAs are requesting for your retention for construction of boundary walls and all this.
Yes, sir. My lord,
I have said to that extent, whatever is on record.
your lordship has already seen our affidavit, my lord, my affidavit, respondent number 4, my lord. We have simply said it's a prerogative of the government to decide whom to transfer, whom not to transfer. My lord. And the lordship has seen the manner in which the petitioner has rushed to the place, lordship.
I
It's
don't
more-
think it is rust.
My lord, your lordship is aware of the geography of Arunachal Pradesh, my lord. From Seppa to Jamri is almost 129 kilometers. From Jamri to Inkyong is almost more than 600 kilometers, my lord. Because on the same, more than 771 kilometers for a person to reach. I don't.
But superintendent engineer, he himself says that to my personal assistant, this man has personally handed over. It is a statement on oath, sir.
Lordship and
How can we ignore that?
and lordship will see the petitioners that writ petition. He says he joins the Inkyong on 7th, assumes a charge on 7th, joins on 6th, assumes a charge on 7th. And on the same day,
What is the distance from superintendent engineer
yes,
office to the Yongkyong, his office?
from Jamari is more than 600 kilometers.
Huh?
More than 600 kilometers.
600 kilometers. From his original Seppa to
Jamari is
superintendent,
129 kilometers.
that is possible on 6th.
Yes. But from
He
Jamari
reached
to,
superintendent engineer's office on 6th.
yes, that's possible.
Then he joined, took charge on 7th.
No. He joined on 6th itself. On 6th itself, he joined
Where?
to Inkyong.
Inkyong.
Yes.
Inkyong.
So almost.
But he has taken over charge on 7th only.
No, that I'm agreeing, Malad.
Huh?
What I'm saying is the on the
That unilateral taking of charge is on 7th only.
yes,
Hmm?
I agree to that.
People may travel whole night.
Malad joined. Whether he joined in the night, I'm afraid.
People may travel from 6th, the night intervening, 6th and 7th, he might have traveled
Yes.
whole night.
And I don't know whether he traveled on 7th to Itanagar also, Malad. Your lordship has seen the report which he has submitted, joining report to the secretary, WRD. It's on 7th. Same.
But other things are WhatsApp.
Then.
That is different.
No, lordship, lordship will see the page is not mentioned in my copy, Malad. but it will, I assume it would be around.
See 44, page 44.
55, 58, I suppose.
58
Most probably, man.
of your affidavit
No,
of which?
they are read petition.
Read petition.
Reply.
Well, it is not 58. There is no page called 58. It's 44, the joining report. Down below
Oh, joining
SKT,
report.
10-11. Only you have soft copy by mail on 7-11-25. Down below, my lord, on the left side.
This is
Page 44.
Office of the Secretary, my lord.
Page 44.
44.
Soft copy by mail on 7/11 and secretary WID 10/11.
I'll just page. No. ये वाला page. ये तो notes नहीं. ये.
Assumption expertise. Yeah, to certainly not.
Assumption of the is given ex parte charge of WRD income 7/11/2025.
7/11.
Yes.
And before that, secretary, so superintendent engineer is on 6/11.
Yes. This page,
That you can find at page 40.
this is a endorsement.
Next are 8.
Endorsement at the left hand side, by the Office of Secretary.
That is official acknowledgement 1196, page 40. Joining report. Before superintendent engineer at Panging. 6/11.
611.
That's different, Malat. I don't.
Hmm?
He has given us a copy, the petition, Malat. In that, there's a endorsement by the Office of Secretary, Malat.
That is in your.
Yes.
Expertise. Expertise. ये normal joining है.
No, I'm not saying about normal joining, Malat. Yes. Lordship can, the copy which has been given to us by the petitioner, Madam. In that, the endorsement of Secretary is there.
It is in the affidavit of the. Oh, I don't know. Page 44. Page 44.
That's different, Malat.
It is below, down below.
No, that's different, Malat. That's why. It's 10/11.
Hmm?
It's 10/11.
Secretary 10/11. And soft copy by mail on 7/11. I don't know whose signature are this.
Page number are mismatched.
Copy which they furnished to us, Malat. Lordship can just give my copy, Malat. Extra idea.
Yeah, this one is all right.
And otherwise, government, page 52, they knew that this has been certificate of transfer of charge is uploaded on 6/11. They knew. That is their endorsement.
You lost will find the endorsement on the left side. The date is 7 months. Office of the Secretary. Repeating नहीं है. Repeating copies.
That is not with us.
That's why, Madam, but here this copy I have received from the petitioner is there in the left hand. Lordship will see the endorsement from the Secretary, Itanagar, on 7.
That is received.
Yes.
On 7/11.
Yes. Madam, he's assumes a charge on 7th at Inkyong, and on same day he's here at Itanagar also.
Oh, that we cannot visualize how this is possible.
That's what, Madam, the I don't know. I think they forgot, Madam, this page. In the writ petition, however, they gave us this. Otherwise, my lord, our stand is very clear, my lord, that there's no any allegation of malice, my lord, on my part.
But question is whether this is legally correct, the order.
Yes.
in
And
terms of the office memo. Now, I'm only on that short point.
Uh,
I may not be correct, or this kind of case has come for the first time.
as for the respondent,
There is no precedent to
Madam, we
rely
are
upon. I have looked at Pubi Lombi,
yes, madam.
but that is a case of similar kind of facts.
Yes.
But he rushed there.
No, madam.
He was, that respondent was 5 was directed to assume charge only after April, but he rushed in April and joined there. And that was held to be wrong. And appellant's retention was recommended by MLA.
Yes. Madam, in
But
the
Supreme
case
Court
of,
has said,
madam, in the case of Pubi Lombi also, madam, the respondent already joined in the place of posting, madam. Because the order was of 2022 and
that
yes,
order was much prior.
yes,
But in the order itself,
yes,
it was clearly mentioned that you go and join after April.
Correct.
Because the post where you are going to join, it is held by an incumbent who is going to retire on end of April. But he rushed there and joined in April
Yes.
in violation of the transfer order itself. That is the case.
but
And the other man, appellant in Supreme Court,
yes, ma'am.
he's both were under order of transfer. And respondent joining was in violation of the transfer order. Because he was supposed to join after April. But he joined unilaterally in April, 15 or 20 April.
28th April.
But that was not the direction of the state government. They said, please join after April. Because this man is holding the post. He is going to retire. That is a fact. Every fact of every case results in the decision.
Agreed, madam. Lordship, but the fact remains that in that case also the respondent joined the place of posting, madam. And it is not a case that madam, government doesn't have the prerogative to madam, modify the transfer orders and all that, madam. Definitely government, and I am bound by the orders of government, madam. I have nothing more.
I admit to all your submissions.
Madam, I have nothing more to argue in this matter because I am bound by the
I
orders of the
admit
government.
to all the submissions, legal submissions of all the councils.
That's why, madam,
Nothing to be decided. Transfer order is not to be interfered with unless it is in violation of statutory norms, unless it is mala fide, unless it is issued by a person who is not competent to pass a transfer order, unless it is infraction of profess norms,
yes, madam.
right?
Yes,
And government has the prerogative,
yes, madam.
who is to be employed where, who is to be transferred where policy guidelines
Yes,
are not enforceable.
yes, madam.
These are mere guidelines.
Yes.
I admit to all.
Agreed, my lord. And in the case of respondent number 5, my lord, here we have filed affidavit.
No imputation to respondent number 5.
In that also we have simply said
No
first
remarks about
Yes,
respondent. If the MLAs want to retain him, it is their,
on the recommendation of
it is their choice.
yes, we have not said that.
But the court is of the tentative view that this order has been worked out, 29/10/2025, and none of the two officers are under order of placing and transfer. This is the tentative view. Yes, government has the prerogative. If they want to retain him or bring him back, the respondent number 5, they can still.
My lord, the office memo.
Yes, MLA. Yes, what do you want to say?
My lord, just one line only, my lord. The office memorandum which says, my lord, it always says that when the officer doesn't hand over the charge, then only the ex parte. My lord, nuances is always there, my lord, in any order, my lord.
Nuances or the acts committed by the controlling officer and the relieving officer that are there to be seen.
But it says, my lord, it
They are to be
doesn't hand
seen
over the charge.
from their statements on affidavit. Yes, for what important public project you want his retention? Your name, please. A? Yes. What boundary wall is an important project? Kitchen is an important project.
Lordship, I have issued your note on the basis of the representation submitted.
You're not verified.
Lordship,
You represent respondent 5 and 6.
no, six.
6. He is a friend of yours.
Lordship, no.
That is your
Lordship, that is there. Yes, however.
personally known to for long.
Lordship, I being the local MLA of the area, of course, I personally know all the officers of the. So it has been.
So he received the representation. You acted like a messenger.
Lordship, representation, Lordship, I received it.
Are you a messenger or have you verified? For kitchen boundary, construction of kitchen boundary and what else? Boundary walls, kitchen for girls hostel.
Ayush building.
Ayush building 35 bedded, not 500 bedded.
This representation was received on 28th October.
At least respondent 2 was measured, saying that only 2 important projects. You have listed 10, 12.
That is the public representation.
Why water resources department engineers are involved in these cases? Boundary walls, Mr. Nabam, actually I got surprised.
Most of the works are Lordship.
And why, Mr. Nabam? Please give your explanation. In the impugn order, why this in the interest of public service is absent?
Because that modification was issued, my lord, of in continuous original order, my lord. In the original order, you also find in public interest. Because it said, my lord, no point, my lord, repeating the same continuation.
Is it?
My lord,
Is it?
my lord, will it make any difference? My lord?
Government is so measured in using words.
My lord, will it make any difference? My lord?
Okay, government is very measured in using words. So 1, 2, 3, 4, 5, 6 words are not required.
No, I'm not on that, my lord. I'm on.
In continuation, I have understood.
I'm on, my lord, using public interest, my lord. Will that be?
Why it is conspicuously missing?
My lord. Because the in continuation, because of that
Okay.
only, my lord. In continuation.
So government always think about using words.
No, my
It is already there, so let us not use.
lord. Will it be necessary using, my lord, again, my lord, in public interest?
Absolutely. Let us see which order, item number 2. Is it there?
My lord, only.
Is it there? Item number 2.
Item number 2. Today's, my lord.
Frequent transfers.
I think they can.
Yes.
Okay.
There you lordship must have noted, my lord, the file noting, e-file notice, my lord. I don't think so. Item number 2. That was fresh, my lord, transfer order, if I correctly remember.
Mr. T. Patil, learned counsel for the petitioner. Mr. R.H. Navam, learned additional advocate general for the respondent number 1, 2, and 3. Mr. P. Tapul, learned senior counsel estate by Miss M. Karwa. Please give the name. And Mr. T. A. Tatak, learned counsel for the respondent number 6. Who is for 5?
4 and 5, man. I'm written. 4 and 5.
4 and 5.
There's no
That
clash
is,
of the
that is also indicative of malafide.
Yes. 4 and 5. Interesting. 4 and 5. This will be
Interesting, something interesting.
no clash of interest.
This 4 and 5.
okay. Arguments are hard, judgment is reserved.
My lord, my lord.
Obliged, Lordship.
Okay.
Athava, item number 1.
May I please your lordship?
Yes.
This application, the petitioner has filed under section 11 of
Heard, Miss
R. Taku, Your Lordship.
Council for the petitioner. This application under Section 11 of the Arbitration Act, Conciliation Act 1996 is preferred, seeking appointment of an arbitrator in terms of Clause 8 of an agreement stated to have been executed between the petitioner and the respondent on 30/11/2022. First of, it is averred that a legal notice has been issued on 7/1/2026 by the petitioner invoking Clause 8 of the agreement, demanding a reference of the dispute to arbitration. Issue notice returnable on so and so. The petitioner shall take steps for service of notice upon the respondent by speed post within 2 working days from today.
Deeply obliged. Item number 11.
My lord, this is a case of that without land acquisitions, the respondent has for the called for the NIT for the construction of that road, which has already covered of the my land, that without give any serve of the notice, any land acquisitions. NIT, that's I challenging for NIT, whereas I have already submitted many representations before the authority for the land acquisitions, my lord.
Yes. Now they have issued a tender.
Yes, they have already issued tenders that without any land acquisitions.
What is your claim? That what is the purpose for tender?
The purpose
Construction of protection wall.
Yeah, protection wall
Protect
by
Lang Itanagar bypass.
Yes,
Doni Dokam Colony Itanagar.
Yes, my lord.
Now, but how you are claiming as a landowner?
Yes, my lord, I am a landowner.
Source?
My lord, the NIT is, my lord, that page number 15, 16, 17. That is NIT which I challenging that this case. Page number 15.
Yes, 15. It is up to, tender document is up to?
My lord, up to page number 113. 1 and 3.
What are these pictures? Excavation. Yes, thereafter 113. Then?
Yes, 113. Thereafter, my lord, I submit the representations before that respondent number 1, the annexure number, my lord.
So, you are claiming on the basis of this gift deed?
Yes, my lord. I'm claiming for that. At least I am not against of any development activities, but as per the procedures.
Well, the Registration Act is applicable in the state of Arunachal Pradesh.
No, my lord. My land is unproperty, ancestral property land. I am not any apply for the government land, like LPC and that.
I am asking a question whether the Registration Act is applicable in the state of Arunachal Pradesh.
Yes, my lord, I applied the Arunachal Pradesh.
Then this gift deed is a 100 rupees stamp paper.
Yes, actually, this is my father's. Whereas my father is old. My father is just as per the record.
No, this gift deed is null and void.
My lord, gift deed is not registered, my lord. But this is as per.
Not registered, then how can it be?
But actually, this land is my ancestral property land, my lord.
Made at the resident of so Itanagar, Bamang Kaniang.
Yes.
Bamang Kaniang is related to you.
Bamang Kaniang is my paternal uncles, my lord.
And
that's
Taya
is my father, my lord.
Father.
Yes, my lord.
Where are their land documents?
My lord, actually, here there is no any land document. This is a unproperty land. As per the practice in the state of Arunachal Pradesh.
What is their stand?
My state is, my lord, at least give for the land compensations or either
No,
it
what is their stand? Stand of the state respondent.
yeah, state
Let us
respondent,
see.
yes, my lord, state respondent, you say that as per the epidemic, he said the land is belong from that IMC, Itanagar
Land
municipal.
is a government land,
Yes, my lord.
which falls under Itanagar Municipal Corporation, particularly Ward number 5, as the land falls under Doni colony between Gonga and Cholang. Therefore, they cannot claim over government land. Then they have disputed.
No, actually, my lord, I have contact with the respondent number 4, that is executive engineers, who is filing by this epidemics. They say that they have wrongly already submitted for the epidemic. The actual land is belonging from that
If he has wrongly
land of the
submitted everything,
petitioners.
what can I do?
My lord, this is the
It
actual.
goes into disputed territory.
Actually, my lord, my submission is that if that department is claimed for their land, then where is the document of the land allotment?
So
At least
where is your document?
my,
First, you have to stand on your own feet.
yes, yes, yes,
Right.
yes.
So how you are standing on your own feet? This gift deed 100 rupees, no. Gift deed is requires as much stamp duty as of a sale deed.
Yes, my lord, I do.
And where is your forefather, uncle or father's claim to ownership?
No, my lord, the year is that this is the ancestor property
Then
land.
they are saying government land.
No, this is the
Who has
post
to
matter. This
decide?
is the full statement, my lord.
Who has to decide?
Because of that, my lord, Itanagar is the some immobile property which they donated to some
Right,
other
Mr.
test, my lord.
Council, who has to decide that? I put it to you. You are saying it is your land.
Well,
They are not acknowledging that it is your land. They
Yeah.
are saying that it is a government land.
yes.
And it falls under ward number 5.
Actually, my lord, this is not to come under of the ward number 5. This is ward number 4, my lord. This is come under ward number 4, not by ward.
Notification, they have annexed some notification also.
Yeah, my lord, this notification, as per the government notification, is not coverage of the my land, my area, my lord. This, as per government notification, is submitted by the governments, but it is not coverage by the this.
Neither you have document, nor your uncle and father has document. Mayor claim will not do in a read court.
Yes, my lord.
In a read court, the issue in anything disputed
Yes.
is to be based on the affidavit.
Yes.
Now, your claim and the affidavit of the state
Yes,
makes it a disputed question.
yes, my lord. But
And
but
where is that? Then you have to lead evidence to establish that you are the owner of that land and your land has been encroached upon or used by the state respondents in constructing the retaining wall, protection wall.
yes, that is why, my lord, this.
That has to be by leading of evidence in a
Yeah.
full-fledged trial.
Yes,
And we do not conduct trial in read court.
yes, yes. If this department started the work, otherwise the damage of my land. So let me the passing of that order, maybe director to deputy commissioner for the respondent number 4 for verification of land, whether land is belonging from that or not.
Now, who is responsible for 3 and 4?
3 and 4.
3 and 4, superintendent and executive engineer.
Mm.
You want an affidavit from the deputy commissioner? Yes, Mr.
Yeah, if lawsuit come to page 124 lawsuit. Before coming to this honorable court lawsuit, the matter was even brought before the concerned magistrate lawsuit. And here lawsuit petitioner was given opportunity to establish his right lawsuit, if any lawsuit. And the London executive magistrate lawsuit has denied lawsuit. dismiss this claim, Lordship. And this particular adjudication, Lordship, is not under challenge.
But this court does not have the competency to decide about the ownership.
That is the
ownership.
No, actually, my lord, complaint was lodged by the responsible board, that is executive engineer, before the deputy commissioners. Thereafter, on the matter was fixed on the 5 March 2026. Now, I was summoned. Accordingly, I appeared before that magistrate. But the magistrate just said that this is my complaint letter, my lord. This is complaint.
No, this has to be established that you are the landowner. Where from it is established?
That is why my lord.
Making a just claim will not do.
Yeah, that is why, my lord, there was
That
no.
is why.
That is only for the
approach the
occupied,
appropriate forum.
my lord, this is occupied land of the forefathers.
Okay, file an affidavit from the deputy commissioner.
Lordship, when this affidavit is there, my affidavit, Lordship, when I say, Lordship, this is a government land, Lordship. Here, yes, no.
It is said by executive engineer, superintendent engineer.
Lordship, there is no, Lordship, rejoinder on that aspect, Lordship, from the petitioner. When there is no regional, Lordship, that is admitted, Lordship.
But
Technically, Lordship.
He is the person who can dispute the claim of the petitioner, deputy commissioner. I think he is the revenue authority.
Yes, my.
3 and 4 is not the revenue authority.
That is correct, Lordship.
Let the deputy commissioner file an affidavit.
My lord, my prayer is just simply direction to the deputy commissioner for the verification of land, whether land is belonging from the state government land or others that.
If you make an adjournment, you can make an adjournment. I will not do that. Based on material, I will simply say that it is a disputed question of fact. You have to go to the civil court.
Okay, let me, my lord, the direction to the deputy commissioner for filing affidavit. For filing affidavit.
Mr. P. Bush, Land Council for the petitioner, Hart, and Mr. Sorensen, Edition, Advocate General. So you are senior
government advocate
for the state respondents, post of
for all the rest.
For all the respondents, having regard to the dispute raised in this petition regarding the ownership of the plot of land, and affidavit from the respondent of 5 appears necessary. Mr. Smenso has sought for and is granted 4 weeks' time to obtain an essay instruction and to file the affidavit in opposition on behalf of the respondent number 4. Leave the case after 4 weeks on date to be fixed by the office. Otherwise, procure some document about your ownership.
My lord, here Arunachal is all that occupied land. There is no any LPC land allotment applied.
It has to be established by.
This is like a land
that you
system,
have the occupation
agriculture system like this.
Civil code.
Horticulture, agriculture like this.
Civil code then. Let us have the affidavit from DC.
Item number 12.
Your Lordship, we need some time to file affidavit here. Lordship. We need some time to file
You need
affidavit.
some time.
Yes, Lordship.
Okay, Mr.
B. Sibo.
B. Sibo, Land Council for the petition is present. Miss
R. Basar. R. Basar, Lord.
R. Basar, Land Junior Government Advocate. Who are the respondents? For all?
All the respondents.
Has sought for and is granted how much time?
3 weeks, Your Lordship.
3 weeks time to obtain the necessary instruction, and to file the counter affidavit. The praise allowed to release the case after 3 weeks on date to be fixed by the office.
Item number 13 to 15.
These matters can be disposed of, my lord. Although they have filed their reply today, but since there is an interim order, it's a matter relating to tender. There is an interim order in item 12. 13.
Item number 13.
13 to 15, my lord. My lord, in item number 13 to 15, my lord, I have filed my affidavit reply against the affidavit reply filed by the respondent for today, my lord.
What is the issue? You are not ready.
My lord, they have filed their reply. Oh, we are ready. They have filed it today. We are ready.
But whether it is in the record or not, my lord, that is
record. I don't know.
Yes, ma'am.
If you can,
Yes,
if you ask, I can call for. Yes.
My lord, can it be on day after tomorrow, my lord, if possible?
Day after tomorrow.
Yes, ma'am.
Okay, day after tomorrow. Yes, ma'am. Okay, Mr. K. Tari.
No, my lord, Islampur.
Land Council of Petitioner has submitted that an affidavit in reply on behalf of the petitioner has been filed today and the same is not on record. So he has sought listing of the case on Wednesday. With the said affidavit in reply on record, Mr. Ann Roton, Learned Traditional Advocate General for the state respondents is present and has agreed to the said prayer, raise the case accordingly. Also, raised to test out the affidavit in reply, comma, stated to have been filed by the petitioner today, comma, to tag with the case record. There is a case on so and so. Wednesday.
Yes, my lord.
Case-
Interim order.
case.
Interim order, my lord.
Same order.
My-
14, 15. Interim order in past. Okay.
In item,
Cases.
Yes,
item
same order.
Interim order, whoever passed earlier shall continue till the next date of listing.
Obliged.
Item number 16.
Lordship, here I'm supposed to bring instruction, Lordship.
Affidavit.
I need some more time, Lordship.
Okay. Mr. Nibo.
oh, yes, M. Nibo.
My lord, I am appearing for respondent number 1, 2, and 3, my lord. Power Grid Corporation of India Limited. We have already filed our detailed counter affidavit, my lord.
Okay.
Item
number?
Item number 16.
16. In 16,
I think
there is no
my
power.
brain is in another case.
No, Power Grid is not a party here.
My lord, I thought it's 18. I'm so sorry, my lord. I apologize.
M. Nibo, Learned Counsel for the Petitioner's friend, Mr. Ann Roton, Learned Traditional Advocate General.
S. Tapping.
Huh? Oh. Learned
S. Tapping.
Tapin, Learned Senior Government Advocate. For what the respondent has prayed for. And is granted how much time?
2 weeks.
2 weeks to file the counter affidavit. First of raise the case on so and so. What we did after 2 weeks?
13 May. Item number 17.
But respondents have not yet filed their affidavit.
Trying to review.
May I, your lordship?
But this is also almost the same which in other cases. This is proposed delay reserve forest.
They have filed affidavit.
Actually, here in this matter, your lordship, they have not served extra copy to us, your lordship, till today.
Then you serve extra copy then
Yes.
by tomorrow.
By
How much time you need?
Then at least 2 weeks time may be needed, your lordship, to obtain
Okay.
instruction.
And you are for state. You are
Yes,
for
sir.
Union of India.
Yes.
Okay, Ministry of Defense. Mr. T. Patil, Learned Counsel for the petitioner is present. Heart. And Miss
P. Pangu, your lordship.
Learned Junior Government Advocate
Yes,
for
sir.
the respondent number 1, 2, and 3. And Miss
O Jarang, your lordship, appearing on behalf of M. Kato,
M. Kato, DYSGY for the respondent number
4 and 5, your lordship.
1, 2, 4, and 5. Post of the Learned Counsel for the petition shall furnish requisite number of extra copies of the petition to Miss so and so by tomorrow. Post of on receipt of the copies of the affidavit. The respondents will ensure that their counter affidavits are filed within 2 weeks' time.
2 weeks, yes, sir.
Okay. List the case on so and so.
Obliged, your lordship.
Obliged.
Item number 18.
May I please, ma'am?
My lord, here all the respondent they have filed their affidavit, my lord. So matter may fix for admission hearing, my lord.
Okay.
My lord, here I appear for respondent 1, 2, and 3, my lord, Power Grid.
And Taji,
Yes, my
petitioner. Which product, Mr.? Your name, please. May I know your good name?
My lord, I'm N. Khera, my lord, Nitin Khera.
And Khera.
N. Khera.
Land Standing Council, Power Grid Corporation of India. For the respondent number 1, 2, and 3.
My lord.
Yes, which for 4?
I'm for the state, your lordship.
Tell me the respondent number.
5. I'm for respondent number 5, your lordship.
Respondent number 5. Land Government Advocate. 4.
My lord, 4 is State Power Department.
Mr.
Yes, Your Honor, on behalf of L.
On behalf of Mr. L. Parmel, Land Standing Council, Power Department, for the respondent number 4. For the Land Council for the parties have submitted that the exchange of pleading is complete. Full stop. Yes, when do you want?
My lord,
Release the case.
14th of May, my lord.
Release the case on 14/5/2026 in the admission column. As sought for by the Land Council for the parties, huh?
Item number 19.
May I please, Your Lordship?
Yes.
So earlier occasion, my lord, we have taken some time for filing rejoinder.
Yes.
But unfortunately, my lord could not file. So I need 1 week more time, my lord, for filing rejoinder.
Mr. U. Decker, Land Council for the petitioner, has sought for and is granted a further 1 week time to file the affidavit in reply. Full stop. Mr. P.S.
I'm for private respondent number 4.
4.
Yes.
Mr. So-and-so, Land Council for the respondent 4. Who is part of it? Mr. So-and-so, Tapin. 1 to 3 are present. Release the case after a week on a date to be fixed by the office.
Item number 20.
This case, I have retired on 31/7/2020 as Director of Urban Development.
31/7/2020.
And I have processed my pension documents, but till today, my pension has not been cleared. Now, my lord, the director.
You are in receipt of this thing? Provisional pension?
No, my lord, nothing. Nothing, my lord. Now, my lord, the director of pension, respondent number 4, he has filed an affidavit, my lord. He's saying that no documents, records has been sent from the department. Now, my only responsible submission is, my lord, without wasting further time, directions may be given to the department.
You were suspended.
I was suspended
earlier.
also. That also the
For a criminal case.
Yes.
Then you were acquitted.
Acquitted.
Then obtain all
with one observation that this may be disposed of as per law. If I have not submitted the entire documents, I may be given liberty to adduce the documents, additional documents.
Affidavit file. Affidavit
There is
file.
no affidavit.
Huh?
No affidavit. We don't have.
No affidavit. Oh, here it is.
See paragraph 5, Malat. May I read, Malat? That with regards to statement made in paragraph 6 of the writ petition, the answering the respondent begs to state that the petitioner has correctly stated in para 1 that pension gratuity are processed by the Director of Audit and Pension, and that the requisite pension papers are required to be forwarded to this directorate by the concerned office department for necessary action. However, in the instant case, neither the petitioner service book nor the pension papers have been received in this directorate to date. In the absence of the aforesaid mandatory records documents, processing and settlement of his pension and other retirement benefits cannot be undertaken. It is further, this is only situations, my lord. My lord, without awaiting the department's affidavit, it can be.
Yes, Mr. Tapin.
What happened here? Earlier, the petitioner was appointed as assistant town planning. Then he was promoted as town planner, ad hoc basis. And further, from town planning to director, again ad hoc. So these are the situations, the background, I have spoken to the authority. They said, this promotion has to be regularized first, because by holding the DPC on national basis, then this further process can be done. Then I said that it took more than 5 years because he was retained in 2020. So they said it's under process. So therefore, I have not yet received the instruction. This is my verbal discussion with them, and the parawise is pending before the law department for vetting, So therefore, my just submission is that.
But at least he has the right to receive provisional pension.
Provisional pension. For that purpose also, since because that post where he was, it was not regularized.
But 6 years is too long.
Too long. Exactly, Therefore, my submission is that this matter can be disposed of, recording my submission, to consider this promotion as per the law, and then to send the pension paper to the audit and pension so that his pension can be.
So entire exercise can be completed when?
That part was 6 months may be given.
Then within 1 month you start paying provisional pension.
Difficulty is provision pension has to be fixed with a particular post.
Whatever you can adjust after that.
Yes.
That can be adjusted.
Can be adjusted.
Otherwise, provisional pension, whether he is this or that, some dispute, but provisional pension can be from the substantive post.
But substantive post is the part.
Whatever you regularize in the meantime.
That can be done.
Okay, I'll record your submission.
Close.
Heard Mr. T. Partin, learned counsel for the petitioner, and Mr. S. Tapin, learned senior government advocate for all the state respondents. Also, the case projected by the petitioner, comma in brief, comma is that during his service tenure, petitioner service was under the Department of Town Planning and Urban Local Bodies.
Yes.
Comma, Government of Arunachal Pradesh. The petitioner stated that during his service tenure, comma, he was placed under suspension in view of registration of a criminal case against him, with PC case number 11/2020. Full stop. Registered under sections 465, 471 IPC, read with section 13 within bracket 1 within bracket small d and 2 of the Prevention of Corruption Act. Full stop. After a full-fledged trial, upon framing of charges against the aforestated sections, comma, the petitioner was acquitted from the charges by judgment. An order dated 13/1/2019 passed 13/11/2019 passed by the Court of Learned Special Judge within bracket PC Act, West Session Division, UPIA, Papum Pare District, within bracket AP, the trial court for short. Full stop. It is stated that with no appeal being prepared by the state against the judgment and order dated so and so, the acquittal of the petitioner from the state charges has attained finality. Full stop. Para. Subsequent to the, then you got reinstated.
Well, yes, reinstated.
Subsequent to the judgment and order dated so and so, the petitioner was reinstated into service. First of all, after serving his remaining service period, he retired from service on attaining the age of superannuation on 31/7/2020. First of all, it is the further case of the petitioner that he retired from service as the Director of Town Planning and Urban Local Bodies, Government of Arunachal Pradesh. First of all, after his retirement on superannuation, the petitioner submitted his pension papers for release of his pension and other retrial benefits. What is paragraph 14, Mr. Pardin?
In some other cases, he was therefore this authority was
related to any misappropriation or some criminal other
no,
IPC
some
offenses?
private issues.
Private issue.
Yes.
Okay. When did you submit your pension papers?
Well, right after all the clearance.
Submitted his pension papers for before the competent authority for release of his pension and other retirement benefits like gratuity, commutation value, leave encashment, GPF, stroke CPF, etc. When the retirement benefits were not released, were not processed and disbursed to the petitioners in an expeditious manner, the petitioner made representations on various dates, including para 7 of the session. Full stop. Agreed by, and dissatisfied with the delay in processing the pension papers of the petitioner and the delay occurred in release of the pension and other retirement benefits of the petitioner has approached this court by the instant writ petition seeking inter alia a direction to the respondent authorities to process and release the same in favor of the petitioner forthwith. First of para, an affidavit in opposition has been filed by the respondent number 4, wherein it is stated that the Directorate of Audit and Pension, after processing, comma, is required to forward the concerned office stroke department after
Department of Town
processing
Planning and Urban
pension-
Local Bodies.
Huh?
Town Planning and Urban Local Bodies.
Okay. The Directorate of Town Planning and Urban Local Bodies, Government of Arunachal Pradesh, and the Department of Town Planning and Urban Local Bodies, Government of Arunachal Pradesh, after processing the pension papers, comma, required to forward the same to the Directorate of Audit and Pension, Government of Arunachal Pradesh, for necessary action. Full stop. In the affidavit, comma, it is further mentioned that neither the petitioner's pension book nor the pension papers have been received in the Directorate of Audit and Pension, Government of Arunachal Pradesh, and in absence of the said documents, comma, the matter of pension and other retirement benefits in respect to the petitioner could not be processed and settled. First of para. Mr. Tapin Lanit, senior government advocate appearing for a state respondents, has submitted, comma, on instruction, comma, the petitioner was serving in the substantive post of
Assistant Town Planner.
Assistant Town Planner. Post of. Subsequently, comma, he was allowed to serve in the post of
Town Planner.
Town Planner on ad hoc basis, and thereafter also as a Director of Town Planning and Urban Local Bodies on ad hoc basis. First of, he has submitted that the Department stroke Directorate of Town Planning and Urban Local Bodies, Government of Arunachal Pradesh, are considering the matter of regularization of the petitioner in the post of Town Planner and Director. And in the process, comma, the delay in settling the matter of pension and other retirement benefits has occurred. First of, he has submitted that after settling the matter of regularization, in the post of Town Planner and Director in the Directorate of Planning and Urban Local Bodies, Government of Arunachal Pradesh, the pension papers of the petitioners would be forwarded to the Directorate of Audit and Pension, Government of Arunachal Pradesh, for further processing and release of the requisite pension and other retirement benefits to the petitioner. First up, he has submitted that to complete the entire formalities, a period of 6 months would be necessary. First up, on a query to Mr. Tapin, he has submitted that despite though the petitioner has retired from service on superannuation on 31/7/2020, no provisional pension has been released in favor of the petitioner till date, full stop. As a period of more than 5 years, 8 months has elapsed since the retirement of the petitioner on superannuation on 31/7/2020, the petitioner has the right to, the petitioner is at least vested with the right to receive provisional pension, which in a case of non-settlement of pension, is to be dispersed forthwith. Taking into consideration the submission of Mr. Tapin Lanet, Senior Government Advocate, this court is of a considered view that instead of keeping this writ petition pending, this writ petition can be disposed of with a direction to the state respondents to complete the entire formalities regarding regularization of the service of the petitioner in the post of town planner and director of town planning and urban local bodies government director, town planning and urban local bodies, and thereafter to process and settle the claim of the petitioner for pension and other retirement benefits within as expeditiously as possible, but within an outer limit of 6 months.
But the 3 months
from the date of, no, it will not be possible.
From date of receipt.
Within a period of, within an outer limit of 6 months from today.
From date of receipt.
From the date of receipt of a certified copy of this order at the office, from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number 3. Right? Full stop. The respondents shall ensure that the ensure to disburse the provisional pension of the petitioner, taking into consideration his substantive post within a period of 1 month from the date of submission of the certified copy of the this order.
While referring substantive photos, within bracket, if it's mentioned assistant town planner, no, sir.
I'll just say substantive.
Substantive.
You take it.
Lordship,
Within a period of 1 month.
1 month. That lordship, not respondent number 3, respondent number 2, lordship.
Respondent number 2
is the authority.
With the with the observation made and direction given, the writ petition is disposed.
Obliged, Lordship.
Item number 21 and 22.
My lord,
Your Lordship.
I appear for respondent number 5, my lord, in terms of order dated 23/3/2026, my lord. In IA number 45 of 2026, we were directed to file an additional affidavit bringing on record the recording of the Zirat. My lord, we have, in compliance of the order, we have filed the said affidavit, my lord.
My lord, will be requiring some more time to file our affidavit.
Okay. Which one order is to be passed in both? Heard Mr. S. Moe, learned counsel for the petitioners as applicants. Mr. N. Ratan, learned additional advocate general for the respondent respondent stroke opposite parties number 1 to 4, and Mr. N. Khera, learned counsel for the respondent as opposite party number 5. First up.
In writ petition,
Mr. Khera has submitted that in terms of the order dated 23/3/2026, an additional affidavit.
My lord, additional affidavit.
Yes.
Additional affidavit has been filed on behalf of the respondent as opposite party number 5 to bring on record the assessment of Zirat compensation. Right?
My lord, my lord.
Right, Mr. Khera?
My lord.
Zirat.
Zirat.
Yes.
Okay. First off, Mr. Ratan. appearing for the respondent number
1 to 3 in the petition.
1 to 3. Respondent number 1 to 3 has sought for and is granted. How much time?
My lord, further 2 weeks time, my lord.
Okay, has sought for further 2 weeks time.
My lord, matter may be listed on 15th of May.
To file the counter affidavit on behalf of the said respondents. Full stop. What date you want?
15th May, my lord, 15th of May.
Possible, Mr. Ratan?
Yes, my lord.
Okay.
15 will try.
As sought for by the learned counsel for the parties, list the case on. So, 15.
My lord,
15.
my lord, for item 18, I had appeared a while ago, my lord. Inadvertently, I prayed for 14th of May, my lord. If that can also be made on 15th of May, item 18, my lord.
Find out.
Yes, Lordship. It was fixed on 14 May.
18. Who was the counsel? Okay, give 15.
Yes, my lord.
15 is what?
My lord, Friday.
Okay,
Friday.
Highly obliged, my lord.
Item number 23.
My lord, before other side starts, my lord, last time your lordship has given us to take instruction, my lord. So I totally relied my brother, my lord, because they prepared the DPR. Whether this village falls under that highway or not, my lord. My lord, the things when my lord forwards, my lord. Now the NSPC have written to the deputy commissioner asking, my lord, whether this area falls under the highway or not, my lord. So, my lord, that exercise now we have to carry that, my lord. So we'll be reckoned some more time, my lord.
What is your instruction?
The same, my lord. That is the instruction, my
They are
lord.
written to deputy commissioner.
You have written to deputy commissioner. You don't know.
They don't know, my lord.
It is not clear.
Huh?
In DPI, it is not.
DPR not clear.
DPR
Which
not
villages the alignment would go through?
Go through, correct, my lord. So I'll be recurring some more time, my lord. ये तो आपके पास भी है ये अभी है अब उल्टा हमको प्रेशर
So NHIDCL is writing to deputy commissioner.
correct, my lord.
So Mr. Nabam, you have to answer.
My lord, whereas they prepared the DPR, my lord. My lord will answer, my lord. His lordship may kindly give us some time, my lord. My lord, can it be fixed on, my lord? Mantra Kurla.
6.
8, my lord. Friday, my lord. Till then, my lord, we'll try our best to get the instruction, my lord.
Okay. Mr. T. Partin, Learned Counsel for Petitioners is present. Mr. R.H. Navam, Learned Additional Advocate General of National Protest for the respondent number 1 to 5. And Mr.
RB.
R.
B.
Now your representation is solved. Issue of representation?
Yes.
In the other case?
Yes.
Okay. Mr. R.B. Jadov. Sorry, Miss Y. On behalf of Mr. M. Kato, Learned Deputy Solicitor General of India for the respondent number 6. And Mr. R.B. Jadov, Learned Counsel for the respondent number 7.
6 and 7.
Only
All are present.
7.
All are present, huh? Mr. Nabam and Mr. Yadav have sought for time to obtain the necessary instructions in deference to the have sought for time till 8/5/2026
My lord.
in deference to the order dated 20/04/2026. Full stop. Two aspects, right? About the alignment of the proposed frontier highway and whether the villages
Falls under that.
5 villages. Okay. As sought for by Mr. So-and-so and so-and-so, release the case on so-and-so, 8/5.
My lord. Deputy honor.
Item number 24 and 25.
Why it has come?
My lord, the
Service report.
yes, your lordship. My lord, the file noting shows that the service report in respect of respondent number 4, your lordship, is still awaited
Let me
and
take one by one, 24. You are Miss
D. Tamuk, your lordship.
D. Tamuk
Yes, your lordship,
for the petition.
for a petitioner.
Yes, Municipal Corporation.
Yes,
Who?
my lord.
Mr.
El Kurdu, my lord.
L. Kutum.
Yes, my lord. Standing council.
Standing Council.
Yes, my lord. I am
Itanagar Municipal Corporation.
Yes, madam.
For the respondent number
1 to 4, madam.
1 to 4.
Yes.
And Miss
I'm M. Harangbam.
M.
Harangbam.
Land Council for the respondent number 5.
No, my lord. She is
Just a minute, just a minute, just a minute. So all are represented now.
No, your
No,
lordship,
my lord.
she'll be appearing in another petition.
She is for.
You are not for this man.
Respondent number
Yes.
5.
Srimati Likha Nari Tadar.
Yes, your
Not
lordship.
for her, madam.
Not for her. Okay. What about your affidavit?
My lord will file by next time, madam. Next date, madam.
How much time?
Well, 3 weeks, madam.
Okay. And you have to take fresh steps upon respondent number 5.
Yes, your lordship. In fact, the respondent number 5 is the mayor, your lordship. However, we have also made her in as a
But if you want to delete, make a
Yes, no,
formal
we'll-
application.
we'll take fresh steps on her.
Okay. In view of the office note dated 24/4/2026. As per office note dated 24/4/2026, answer notice in respect of the respondent 5 has been received back. First of Ms. So-and-so, Learned Counsel for the petitioner, has sought for another opportunity to take steps for service of notice upon the respondent number
5.
5. First of the prayer is allowed, the petitioner shall take fresh steps for service of notice upon the respondent number 5 by speed post at her proper and correct address within 3 working days from today. Post of Mr. So-and-so, Land Standing Council. You represent 4 also?
Yes, madam.
Okay.
1 to 4, madam.
Itanagar Municipal Corporation has submitted that he would represent the respondent number 4 in addition to the respondent number 1 to 3. First of Mr. So-and-so has also sought for and is granted 3 weeks time,
madam,
to obtain necessary instruction and to file the counter affidavit on behalf of the respondent number 1 to 4. First of list the case on so-and-so. The interim order passed earlier shall continue for 3 weeks. Then item number
25.
20 May.
25. This is 25. WPC. Okay. Miss So-and-so for the petitioner. Mr. So-and-so for the Land Standing Council, Itanagar Municipal Corporation for the respondent number
1 to 4, madam.
1 to 4. There is no private respondent.
No private respondent.
Who is for the petition? You are for the petition.
Yes, madam.
Oh, you said that I am for the respondent.
No.
Miss.
Miss M. Harangbam.
Okay. Peruse the office note dated 24/4/2026. First of Mr. So-and-so, Land Standing Council. Itanagar Municipal Corporation has submitted that he would also represent the respondent number 4 in addition to the respondent number 1 to 3. First of he has further, Mr. So-and-so has further prayed for and is granted 3 weeks time,
madam,
to file the counter affidavit on behalf of the respondent number 1 to 4. Full stop. Release the case same date.
20 May. 20 May.
With WPC number 90/2026. The interim order passed earlier shall continue till the next.
Item number 26.
Yes, sir.
I'm told that this Honorable Court is not taking up any contested matters. Some difficult, I have understand, Madam.
No,
Well,
I am part to recovery, but
Madam, yes. No, we'll not
that
talk.
day I could not indicate, but I am on
Well,
path to recovery.
I am resisted more by my unfriend. Every time I appear, he is resisting very seriously. So I have taken a, my lord, path of least resistance. And I pray that there is a representation. I'll just indicate, my lord, what is the background. The lordship will direct the authority, let the authority take a decision. Thereafter, if it goes against us, we'll again come before lordship. And I'm giving the background.
Only for disposal of representation that.
Well, I'm
on
giving,
merits, we'll take into account the facts and circumstances of the case, and on merits.
my background,
what is the case?
My background is like this. There is a hydroelectric project in Ranganadi River. Petitioners before your lordship are falling within the project affected area of that project. The government has framed a policy in 2008 saying that there is one area where the infrastructures and other required installations of the project are there within the shorter range. The area will be called project affected area. And the area surrounding that area, that bigger area, will be project affected zone, PAZ and PAA. We immediately fall in PAA, my lord. Now, there is one guideline of 2021 which says that the local area development fund to be generated from there itself will be distributed between the people in the project affected area and the project affected zone in 50-50 share. Subsequently, in 2022, there is another guideline overriding that, saying that no, it will be 100% for the project affected area. So our share of compensation will be more. Thereafter, my lord, since the guideline and the bylaws itself provide that it has to be implemented through the agency of the state, which comprises of some officers, including the deputy commissioner. A meeting was accordingly held. In that meeting, my lord, on the request of the local MLA, while our share was 100%, he says, no, it will be now 50-50. That is the grievance. Now, a decision has to be taken by the authority whether, in terms of the present policy, my learned friend's client has taken a stand that no, the subsequent guideline, bylaw, providing for 100% of the local area development fund for the PAA is a general one. It doesn't apply to the Ranganadi project. Earlier one was specifically for Ranganadi. We say that no, subsequent one is a general one. It does not exclude any of the projects, particularly Ranganadi. It's a general one for the entire state. So it is being subsequent and it being general, it should apply to all. And if it applies, then we get 100%.
Now, if they have taken a stand in the affidavit,
My lord,
in such a manner,
they have taken a stand.
who is the authority who can take the decision?
No, but I'm coming to that, my lord. Here, they have taken a stand on the basis of the my lord, let's make straight away come to page 69. Government of Arunachal Pradesh, etc. Minutes of the local area development committee meeting held on 23/2/2026. In pursuance to Chief Engineer Monitoring, Department of Hydropower Development, Government of Arunachal Pradesh, wide Lieutenant Dated Swenso, and subsequent meeting notice Swenso, dated UPA, the 19th February 2026. A meeting of the local area development committee of Panior Lower Hydropower Station, former Ranganadi REP, NEPCO Limited, was held on 23rd of February 2026 in the conference hall of DC, Papumpare, under chairmanship of Ms. Vishakha Yadav, IAS, Deputy Commissioner, come Chairman, LADC, Papumpare. The following officers, members attended the meeting. Now, on top of this list is the MLA of 14 Doimuk Assembly Constituency. Now, let me straightway turn to the next page, that is page 71. the relevant resolution, my lord. Others are not relevant. Agenda number 4, right hand side, my lord. Agenda number 4, suggestion from Honorable MLA 14 Doimuk. Sri Swenso, Honorable MLA 14 Doimuk empathize the House present for judicious utilization of LADF for local area development under PAA and PAZ as per government guideline LADF 2021. He further said that this LADF will exist till the end of project life. So he requested everyone to cooperate and contribute for overall growth and development of the locality and state in general. In view of the fund allocation for the year 2023, 2024 and 2025, he suggested to share the fund in PAA as 50-50 ratio to maintain the equality. He further said that the PAZ fund shall be as per gazetted notification of Government of Arunachal Pradesh. Agenda number 5, annual action plan received from Swenso. Now he has given a table also, you will find under ADC Kimin, which actually falls in the PAZ mainly, my lord. You will find serial number 1, serial number 2, 3, 4 are the areas of PAZ. For them, the allocation of fund is shown. Only serial number 4 is the PAA in the Kimin ADC, under Kimin ADC. And the remaining, Sagali, the entire area falls under PAA. For them, 115.34 lakh. Now, it is not a decision of the government, my lord. It's a committee which is meant to execute the guidelines. Now, if your lordship goes to the guidelines, just 3 pages I'll show, my lord. First, your lordship will see the 2008 guidelines at page 18, my lord. This is the first guideline of 2008 by the government of Arunachal Pradesh. In exercise of powers conferred by clause 3 of article 246, page 18. In exercise of powers conferred by clause 3 of article 246, entry number 17 in the 7th schedule, list 11, state list of the Constitution of India, the governor of Arunachal Pradesh is pleased to notify the hydropower policy 2008 in the state as follows. Now, it's a hydropower policy of 2008. Right hand side, Lordship will find page 19, serial number 1.8. The hydropower policy 2008 of Government of India has underlined the concern that despite being recognized as
Which paragraph?
Page 19, right hand side, second paragraph, 1.6. The hydropower policy 2008 of the Government of India has underlined the concern that despite being recognized as a relatively benign and renewable source of energy, the share of hydropower in the overall generating capacity in the country has been steadily declining since 1963. In the national policy 2005, water is envisaged as a prime national resource, and in the planning and operation of system, water of allocation priority has been placed in the order of drinking water, hydropower, ecology, agro industries, non-agro industries, navigation, etc., etc. Then 1.10, my lord, you will find slightly relevant. The state's rehabilitation and resettlement policy 2008 for the project affected people have been formulated on the lines of the National Rehabilitation and Resettlement Policy 2007, providing greater benefits to the affected families in view of the scarcity of non-forest land and over dependence of the tribal population on
those are forests.
Yes. Now, relevant is 9.14 at page 22, what we'll find the relevant part regarding the creation of fund. 9.14 at page 22, my lord. An additional 1% free power from the project would be provided and earmarked for the local area development fund by the developers. The state government shall also provide a margin, matching 1% from its share of minimum 12% free power as recommended in the Government of India's Hydropower Policy 2008, if considered necessary by the state government, keeping in view the development requirements of the area. So the fund is to be created Now, so far as allocation of fund is concerned, my lord, lordship will find at page 44, my lord. This is the notification of 2/7/2021. In exercise of power conferred by clause 9.14 of the Hydropower Policy 2008, the Governor of Arunachal Pradesh is pleased to order creation of Local Area Development Fund (LADF) from 1% share out of its share of 12% free power being allotted to the state government from Ranganadi HEP 40 so and so. Now, down below lordship definition is there. Roman 2 is the project affected area. Project affected area means the area where actual project components including submergence area, muck dumping area, mine, quarry area, infrastructure, including roads, project, dedicated township offices, construction facilities, welfare facilities, and any other facilities directly related to the project area are located. Now, Roman 3 is the project affected zone. Project affected zone means the area surrounding such project affected area, where impact of the project on the lives of the people is considerable even if no direct project activities taken place there. So this is the difference between the project affected area and project affected zone. Zone, the area falling within the zone, my lord, is not directly affected. Still, something is given, and initially it was 50-50, and subsequently, my lord, page 47 पर देखो 8. My lord, may kindly turn to page 47. I'll show only the relevant parts. 47.
Yes.
At the bottom, my lord, you'll find first, my lord, this serial number 8. The local MPs and MLAs shall be the invitee to every meeting of all the above committees. The functions and responsibility of the LADC. Timely realization of contributions to LADF, etc., these are there. Next page, Lord, will find parameters for allocation of fund. So it was initially, this table is there. First row is project affected area 50%. And the norms for allocation of fund on the right hand side, Lord, will find project affected zone 20 plus 15 plus 15 is 50. So it was 50-50. Then, my lord, Lordship will kindly have a look at page 50 at the bottom, serial number 11. The state government shall have the power to amend these guidelines from time to time as may be deemed expedient. Now, Lordship will kindly see page 52. Again, my lord, in exercise of power conferred by 9.14 of the Hydropower Policy and amended clause 28(6) of Small Hydropower Policy 2007, the Governor of Arunachal Pradesh is pleased to order creation of Local Area Development Fund. Now, these guidelines will be called Local Area Development Fund Guidelines of Hydropower Electric Projects in Arunachal Pradesh.
I have in a earlier one,
My lord.
I have seen small hydropower policy.
Yes.
In the previous one.
My lord.
Somewhere it is mentioned. Where is the earlier one?
44. It starts from 44, my lord.
Earlier policy?
My lord, 44.
No, earlier that gazette.
Oh, that is page, my lord. 18, my lord.
This is come to page clause 1.9.
My lord, state has already notified the Small Hydropower Policy 2007 for the development of hydro project up to installed capacity of 25 megawatt. Is up to this one is 405, my lord. 405 megawatt.
You are wrong, Anudi.
Yes, Ranganadi is 405, my lord.
This page 52 will be a small hydropower policy only.
Page 52.
No,
my lord. They have said in exercise of power conferred by clause 9.14 of the Hydropower Policy 2008 and amended clause 28.6 of small hydropower policy, the governor is pleased to order. So they have taken everything. Exercise the power under both.
When it was published, 15 June.
It was 2022, 15 June 2022.
Yes.
Now, if your lordship goes
For
to
projects
above 25 megawatt, 2% of sale proceed from power generation, 1% additional contribution from developer, and 1% from 12% free power of the state. This is how the fund is created. And subpara 3, my lord, Governor of Andhra Pradesh in exercise of power conferred by Article 162 of the Constitution. So he's exercising his executive power, my lord. Now, if your lordship turns to page 58, the parameters for allocation of fund, the LADF amount shall be allocated 100% to PAA. And we are relying on this manner. The amount received in LADF shall be solely utilized for local area development fund. Now, my lord, when this committee, there are committees for implementation, as your lordship has seen. Now, when this committee sits, committee is to implement the policy of the government.
Now, who are the petitioners?
Petitioners are persons falling within the PA area, project affected area.
Your project affected families?
Area, yes, my lord.
Families?
Yes, my lord. Falling within PAA, project affected area, where installations will take place and will be directly affected. Now, the committee which sits for implementing the policy of the government changes the policy, questions whether they have the power to change the policy of the government.
What is the stand taken? Now, who has taken the stand?
Affidavits.
Affidavits are filed already.
Affidavits are filed, my lord. Affidavit is filed by my lord, respond number 2.
Now, who is the authority? Respond number 2. Is the secretary.
Respond 2 is the secretary. My lord, if your lordship goes to this, my lord, they have not referred to any policy as such. Their only stand is...
He is the policy framing authority.
My lord, yes. My lord, policies are already framed. By affidavit, they cannot show any new policy. What they are saying is, the earlier one was in respect of Ranganadi only, and subsequent one, although is a general one, but it will not apply to Ranganadi. This is something, my lord, this is a stand they have taken. It has got no material to support. And in respect of our second stand, let's see what was the need to hold this committee and refer to those 50-50 and 100%, because you are saying that 50-50 because the new, that is latest 2022 policy clearly says that it will be 100% for the PAA. That is the reason why in the meeting it is clearly mentioned that no, we'll go by 50-50. If it was 50-50, if the 2021 policy was the only policy for Ranganadi, there was no need to reiterate again that no, it has to be 50-50. You are reiterating because you are trying to deviate from the latest and applicable policy of 2022. That is our stand. Page 53. Well, page 53, if your lordship turns for a moment.
Whether it is a case of disposal of representation.
My lord, page 53.
If this authority has whatever.
My lord, authority, your lordship is correct, my lord. If the authority takes a policy, if it was a
has
case,
taken a stand.
my lord, my only submission is, if the facts of the case suggest that no stand was taken and they have to take a stand, and then they take a stand by an affidavit, then it is all right. But here is a case, there is no question of taking a fresh stand. The question is whether the 2021 policy will apply or 2022. And if your lordship just sees one small paragraph at page 53, my lord. Page 53, my lord.
Power developer means to include all ranks.
The State Hydropower Policy 2008, above 25 megawatt, clause 9.14 provides.
Which one? Clause?
Page 53, clause 2, my lord. The State Hydropower Policy 2008, above 25 megawatt, clause 9.14 provides that additional 1% free power from the project would be provided and earmarked for local area development fund by the power developers. The state government
Developers included all the project.
and by the power developers. The state government shall also provide an. And the question is, my lord, there is fund is created. Fund is meant for the two PAAA, and initially it was for both PA and PAZ. Subsequently, when they realized that the area surrounding the actually affected area should not be given from this fund, they have taken a decision of 2022. Now, present affidavit is filed is only for the purpose of showing that no, we will apply the earlier one, not the latest one. On the ground that earlier one is specifically in respect of Ranganadi, the present one is excluding Ranganadi. But 2022 policy, my lord, providing for 100% share for the project affected area does not anywhere say that it does not include or it will not apply to Ranganadi project. And if your lordship finds the power of this committee is only to monitor and supervision, how can they change, my lord? Page 47, my lord. Page 47 at the bottom, it's very clear. Their function is to only monitoring and supervision of the implementation of the schemes approved under LADF. Scheme is approved, government has taken a decision. Now, while implementing and monitoring, they change the decision. Can they do it, man? That is the only question. Well, my submission will be, instead of this honorable court taking a call, if the state government, maybe the highest authority in the government, takes a decision, it will be possibly in the right flow of things, man.
No, otherwise, the policy is framed by the power department.
Yes.
And secretary is taking a stand. Yes.
But secretary is, by an affidavit, he is not relying on any stand of the government. He is filing an affidavit without referring to any fresh stand. He is taking a different
I have not read. I have not read.
We have read it. We do not. I have read it, my lord. They do not refer to anything new.
As per
The affidavit is absolute silent about any fresh stand.
Let me read. State and as per.
Page 81 is there, my lord. Running page 81 is their stand, my lord. It is to be noted that these two guidelines are separate. Just two paragraphs, my lord. Page 81.
Till that, what you are receiving, 50% or 100%?
They have not paid anything. Huh? Well, this allocation they have made is even less than 50%.
But otherwise, as per Even if without
No, nothing is paid.
that 2022 policy was followed in your case.
My lord, it is not followed in case of anyone. Fund has not been released till now. We have come at a stage when the fund is yet to be released.
If 2021 is flowed, then we'll get 50%. Getting 25%.
Because it looks like, I don't know, subject to further examination, but it says, something is said, local area development fund guidelines for hydroelectric projects in Arunachal Pradesh 2022.
Yes.
And thereafter it says, it is meant for 2%.
Well,
1% from power developer and
1% from the state government.
State government.
Yes.
But in case of Ranganodi
My lord.
guidelines, it is only 1%. There is subtle change or difference.
That's what I'm saying.
That page 82.
Yes.
You have a development fund LADF or what is LADF guidelines 2021.
Yes.
What is this policy? You have shown me
page 44, my lord.
No, page 18. What is this?
That is a hydropower policy.
Hydropower policy.
Yes.
And that is hydropower policy.
It's a general.
This is different from small hydropower policy from 1.9. And you have taken me to this 2021 policy.
Yes, my lord.
Which page? 40?
44, my lord.
44. This is specific to Ranganodi.
Yes.
It is named as Ranganodi.
Yes.
Maybe called Ranganodi HEP.
Yes. And subsequently,
then the subsequent one,
page 52, my lord.
Conferred by how can we assume that this Ranganodi is included in the second one? Because both are under clause 9.14 of the hydropower policy.
Yes. Subsequent is
Right.
general one. It covers.
Both are conferred.
Yes.
By power conferred by clause 9.1 and plus the hydropower policy.
Yes.
Small hydropower policy.
Yes.
So hydropower policy is the parent.
Parent.
And these two are child.
Yes.
Whether one child or two child.
My lord, since it is a question of, my lord, a policy. First, 2021, you take a policy. By exercising the same power, subsequently, if you take another policy, which one will prevail? That is the question. Now, second one is a general one. It does not exclude Ranganadi. That is my prayer, my lord. It nowhere says that it is in respect of all, excluding Ranganadi. And on top of that, my lord, I pointed out at page 50 at the bottom, my lord, they say that we can amend it.
First one is very specific to Ranganodi.
First one says about Ranganadi, but second one is a general one.
It's include all power developers.
And as I from page 53, it includes all power developers, including the Ranganadi, the power developer for Ranganadi. That's what I pointed out, my lord. 9.9 at page 53, my lord, Roman 2. State Hydropower Policy 2008, above 25 megawatt, clause 9.14 provides that additional 1% free from power from the project would be provided and earmarked for local area development fund by the power developers. Power developers means the power developer for Ranganadi also. NEPCO also. NEPCO is also a power developer, my lord. How can we exclude NEPCO from this expression power developer? They are excluding NEPCO now.
Come to paragraph 14.
Paragraph 14 of my lord.
Their affidavit.
My lord.
Secretary's affidavit. It is very specific.
My lord, they are still saying that 21 guidelines is still existing.
Now come to paragraph 14.
Yes, my lord.
And the region.
Yes.
There is a distinction.
A distinction they have created only on the basis of the amount of fund, extent of
Because this Ranganodi
my lord.
was before 2008.
Yes, my lord, they have this distinction they have found. Other than this, there is no distinction. My lord, whether this distinction is
So
relevant.
who will dispose the representative after this stand?
My lord, this stand they have.
Question.
My lord, my submission is, my lord, this is not a stand, my lord. They have read the two guidelines and wherever they have found any difference, that they have utilized as a basis for the stand. This is not the stand, my lord. 2020, can they say, my lord, that after 2022 policy, which is a recent one, we will still follow 2021 in respect of one particular policy? That is why I'm saying, my lord, let them take a valid decision and let it be taken by the chief secretary, my lord.
No, I have to find fault with that.
My lord,
Mr. Mazumdar, you have to
from
the perspective of
my lord, that's what I'm saying, my lord. Lordship has seen the two reasons they have cited for differing are there in the.
I am not here to differ. If it is found to be reasonable, it is reasonable.
True, my lord, true.
Then this has to be decided. How can we send it to the third party for that? To take a call on the stand of the affidavit?
I have no difficulty. If your lordship decides that I've got no difficulty, then my submission is very simple, my lord. These two aspects.
So this appears to be very special and the other one is very general.
My lord,
how can you subsume 2021 policy, which is Ranganodi HCP policy, into the second one?
My lord, if your lordship goes to the 2022 policy, my lord, the aspects that have been considered will clearly show that it is meant for all. Page 53, my lord, I am showing the expression power developers mentioned here. Can it say that no, we'll exclude?
What you have challenged here?
My lord.
What you have challenged here?
My lord.
That minute?
Minute, yes.
If we go into this,
my lord,
you have a risk of.
I have challenged minutes.
If page 71 is only confined, your case is only 71.
Yes.
That is a different matter whether this MLA can suggest sharing of this. Otherwise it was continued as 50-50. As per Ranganodi policy of 2021, it was continued as 50-50. 2022 policy, it said about PAA 100%. Right?
Yes.
But that is why I asked you whether have you received 100% any time?
Nobody, they have not released any fund to anybody. So neither PAA nor PSZ received any
all
fund
this
till now.
Hisab Kitab is for
Hisab Kitab is going on, my lord.
Going on.
My lord. And my submission is like this, I'll just cut it short, my lord. What was the need for this committee to go into the share if 2021 was the only policy for Ranganodi project, my lord? There was no need to again reiterate that, see, it will be 50-50, I'm telling you. Because it is very clear that 2022 being a general...
This committee does not have the authority to decide on the share.
That's what that is my submission.
Share pattern, how to be distributed. This is to be by the state government.
If that is so, what
those two policies are there.
Absolutely, my lord.
So this, the state government in the power department is not to be influenced by anything.
Yes.
Taken in a resolution by the committee.
My lord.
But while doing so, you have brought to the fore the issue of these two policies, 2021 and 2022. As a result, the stand has been taken by the state respondents.
That I have been compared, my lord, because this committee headed by the MLA has reiterated that 2021 policy because he knew that under the present circumstances, it is the 2022 being the latest.
What you have challenged here?
I have challenged this one, my lord. This minutes at page 71. I say that the committee has my lord, exceeded its power.
31/10/2020. That is 31/10/2020. No, what is 22? What is this 31/10/2020? In your prayer portion? What do you have challenged?
Page 15, my lord.
Page 50.
Page 15. The second page 15, my lord.
50.
15.
Oh, this policy has been challenged.
No, my lord.
Huh? No, come to your prayer portion.
But yes, page 15, my lord. Roman 4. Page 1.
No, page 14, first prayer.
Yes.
What is that? 31/10/2022?
Huh? No, it will key this 21/10/22. Which one? Page kiman?
Inclusion of certain.
Document.
Mr. Mojumdar, have you challenged it ever or not?
Man, I have challenged, my lord.
Which one?
Page 15. Specifically, I have challenged. Page 15, Roman 4, my lord. Issue writ of session.
Yes, what are the other things? Notification you are challenging?
My lord.
1 to 3, what are those?
My lord, these are on the basis of this MOM. On the basis of this Roman 4 prayer, 23 to 2026, they have done it subsequently.
No, what is prayer 1? Just to have a look. No?
Page 63, Lord, should kindly. By page 63, they have included certain villages which are not entitled to. That is why I have challenged this, my lord. In exercise of power conferred by 9.14 of the Arunachal Pradesh Hydropower Policy, it read with cross so and so, and based on recommendation of the Deputy Commissioners of Lower Subansiri District and Papumpara District, Governor of Arunachal Pradesh is pleased to order project affected area and project affected zone and Papumpara District as follows.
That would require some hearing this aspect because this is a notification they have issued. So far, first prayer is concerned.
Yes.
What is the second prayer? Notification 15/6/2022.
15/6, you want to say page 52, my lord.
The second policy. You are challenging? Okay. Seeking direction.
My lord.
As per the second policy, 100%.
My lord.
And what is the third prayer?
Third prayer is that MOM, minutes of meeting.
Going to implement the villages? No, third prayer is some more.
Third prayer,
going to recognize and implement the villages in the notification dated.
That is at page 68, my lord.
Page 68. Prayer 1 and prayer 2, it will need something more. How can we decide on this?
But these are...
Yes, if you confine yourself regarding the authority jurisdiction of the LAD committee.
My lord.
To decide on
that is my basic prayer.
Mayor suggestion of the MLA.
My lord.
to take a resolution which is not within the scope and ambit of the LADF committee.
But that is my main prayer.
If that, only that part.
My lord, that is the only part.
2026.
My lord.
Right.
My lord.
These observations are beyond the purview of the authority and jurisdiction of the committee.
My lord, that is my only prayer.
Because he is only an invitee
And
it has to monitor.
My lord.
It has no power to implement as per their wishes.
That is the matter.
That is page 71.
My lord.
But if we go into inclusion of villages, exclusion of villages,
those are ancillary. Those are ancillary. This is the
that would be that would require an extensive justification.
My lord, I am on this only. My lord, the very language of this minutes of meeting shows that they are aware that there now a new policy has come. We have to again reiterate the earlier one, 21. And that is why, otherwise, my lord, if there was, if it was a case of simple implementation of the 2021 policy being the relevant one, they ought not to have reiterated that 50-50 share, etc. There was no need, absolutely, my lord.
No, that if you go into that deeper, it will be difficult.
And other pairs, I can say, my lord, will not press. I am only on this.
Your representation is only to the deputy commissioner.
And we will file a press presentation to address to the secretary, if your lordship, and direct.
Already. She is the chairman of the committee who has taken the decision.
Yes.
Right.
Yes,
So it's not
she cannot take.
She cannot do. Right.
My lord.
So I can record your submission that so far as function and responsibility of the LADC at page 47.
My lord.
And some decision has been taken at the mayor's suggestion of the MP who is a invitee only.
My lord.
But they cannot shred their responsibilities in terms of the guidelines. And the petitioner is of the contention that after the policy, that guidelines came in 2022, that should be made applicable. And a representation before the secretary, he will take a call. That much. Other prayers,
What I am saying is, let them take a decision that 2000.
other prayers are not.
My lord, I have instruction not to
Yes,
press.
so far as Mr. Ratan.
My lord, in fact, if that suggestion for this
We are confining ourselves to prayer
4 only.
four.
on the background that the committee has taken a decision that the local MLA has given some suggestion and that suggestion has been followed. My lord, that also, my lord.
No, I have understood.
That also.
I have understood, and it is a meeting chaired by the deputy commissioner.
Yes, my lord.
So when a decision is taken by a committee chaired by the deputy commissioner cannot alone take a decision now. That representation is like what?
That apart, it cannot be said that the decision was totally based on the suggestion and advice of the MLA alone. It was a decision minutes drawn collectively by a committee empowered to take a decision. Now just saying that one MLA comes and give a suggestion, that too, as per the guidelines applicable, his suggestions is taken to be noteworthy and representation disposal against his suggestion is
No.
my lord, since
I could understand.
Yes, my lord.
I could understand now. They have taken suggestion from the agenda number 4, page 71, suggestion from the MLA. Right. He says that there should be judicious utilization of LADF under PAAPAZ.
Yes.
Under government guidelines 2021. And he said that fund allocation should be 50-50. Right?
Yes, madam.
And what is the decision taken?
My lord, further, in view of the fund allocation for year 2023.
Page 72.
2023. 23 also it was followed, 24 also followed, and 25. He suggested the share of fund in pay AA as 50-50 to maintain equality.
Right.
To maintain equality.
This
Earlier
is
also this was
1 minute. This is the suggestion given.
Yes.
Now decision is at page 72.
Yes.
Perhaps or not.
Yes, 72.
The House unanimously agreed to share LADF as per the advice of Honorable MLA.
Yes.
The House unanimously agreed to share LADF 50-50 ratio for project affected people for Hajj and Kimin, I don't know. Where is the end or where is the start? And the very agenda number 1, agenda number 2, agenda number 3, and agenda 4. This is agenda number 6, discussion.
Yes.
Where is the acceptance? Which one is the acceptance? The decision?
My lord.
This heading is suggestion.
Suggestion. Ultimately, they have to take a decision.
My lord allows me to make my submission, madam.
Yes.
my lord has seen, my lord, why Ranganadi, this 2021 notification for Ranganadi, why it is specific and why the other notification of 2022 is general in nature. In our affidavit, paragraph 8, it has been mentioned why paragraph 8, affidavit of the respondent number 2, the Commissioner Hydropower, at page 78.
I have read.
Yes, this Ranganadi project was commissioned in the year 2002, prior to coming of the 2008 hydropower policy, madam. And in that, during that time, the NEPCO, there was no MOU with the NEPCO for sharing of funds. Now, since NEPCO was giving 1% to the state, then now the government cannot compel the NEPCO to now give 1%. So 1% share from the to the government, what they were providing, the government has decided to allocate 1% of the share to these project affected areas, families, my lord, and John. Now, therefore, this is specific. The other guidelines is where 1% is given by the developer, power developer, and 1% by the state government from the 12% free power supply, my lord.
Okay.
My lord will kindly see 2008 policy. 2008 policy
14.
at page, that is my learned senior has seen at page, my lord, my page is 22, 9.14. 9.14. An additional 1% free power from the project would be provided and earmarked for local area development fund by the developers, my lord. At page 22. I think 22. My lord. My lord has seen.
There is a clear distinction.
Clear distinction. The state government shall also provide a matching 1% from the share of minimum 12% free power as recommended in the Government of India's Hydropower Policy 2008. This is now 2008 policy. Here 1% by the developers, 1% by the state share, from the state share.
And this Ranganadi project is silent about 1%.
1% of the developers. Marut will kindly see the Ranganadi at page. Marut.
It's page 40.
44. In exercise of the power conferred by clause 9.14, the same clause of the Hydropower Policy 2008, the Governor of Arunachal Pradesh is pleased to order creation of local area development fund from 1% share out of its 12% free power being allotted to the state government from Ranganadi Hydropower. My lord, here the it is confined only to 1% share of the state government, not from the power developer. Now, to make out a case, just saying that these guidelines will not be applicable, has not been superseded. My lord, we have given our stand clearly that it is a specific, this is specific, 2021 is specific for Ranganadi. They cannot say that it can be superseded, it has been superseded. When we have taken a stand, and in the 2022 guidelines also, notification also, it has not said that it supersedes this 2021 guide notification. My lord, therefore, since my lord has heard the matter in entirety, the only question is to be determined whether this notification will be applicable or the 2021 or 2022 will be applicable. Now, there cannot be a saying that the minutes where MLA has recommended is wrong, because it is also as per the 2021 guidelines notification.
50-50.
50-50. So there cannot project affected and how can they say it's a matter of right that we need the 100%? When there are people in the
Yes,
project.
source of fund is different.
Yes.
The very source of fund is different. Regions are different.
When a 2022 power also it says in exercise of power conferred by clause 9.14.
Yes, that is the
main source.
Yes.
Yes.
But the region is quite clear. Ranganadi was completed in earlier to 2008 hydropower policy. And there was no specific power agreement with the NIPCO. So they are getting 12%. Out of that, they are giving 1%. But so far as second policy is concerned, it is quite clear.
It is
I have seen.
1%
This
power developers
Huh.
and 1%.
You see this one? Quite clear. Page 52.
Yes.
52. Now you come to page 53.
Yes.
Roman 2, you have read already.
Yes.
Then white clause 28.6 Roman 3. Then composition of LADF. Thereafter you see the fund 1%
small b man.
D
small
then where is the fund? Fund page 55. The definition is completely distinct. Because from a, say, for example, from an act, two set of rules can be made. From a policy also, two set of guidelines can be made.
I am only putting one question to myself, that 2022, when the government makes a policy, it nowhere says that, see, it will apply to all the areas of the state except Ranganadi. It doesn't say, it doesn't make any reference.
Then we need a hearing on that, whether that can be done. But
Whether
otherwise, primary
whether
view
that
is
is required or not, my lord. Whether the
Now,
petitioners will have a legal
only
right to
one
claim
question.
that it should be reflected.
If by 2022 they wanted to provide a policy excluding this Ranganadi, anywhere, somewhere, there should have been some reference that, see, it will not apply to Ranganadi project because it is prior to that, it's for fund is different, this is different, that is different.
No, fund is obviously different.
No, fund is different only to the extent that state government share is there. But
because you cannot force NIPCO when there was no specific agreement.
But it is a project by NEPCO only.
No, in a subsequent power purchase agreement, but he would contribute 1%.
Yes.
And the state government, out of its 12% share, would
1%
contribute because it is in a hydropower policy.
Yes.
And which is prior to Ranganadi, which is prior to 2008 hydropower policy. Now you cannot take NIPCO into force to contribute 1% because there was no agreement. There has to be power purchase agreement. All these
2000
NIPCO, Adani, all these big companies, otherwise they will not abide. Be it as instrumentality of the state. There is no agreement, nothing doing. Court cannot force.
Only, if they want to say that, see, in the 2022 policy, we have framed policy for projects where the state government is also making a contribution of 1%. Sorry, the developers. There we will give you 100%. But in the earlier one, it is 50-50. Can they make this difference?
The question is first from the source, how it goes down.
Source is
different. Fund source is different. They have made it clear. And yes, there could be an element of arbitrariness in that distribution. But we have to come from the source. From Manas Sarovar, Ganga, Jamuna, Brahmaputra. But if we from Manas Sarovar we come, then they are flowing in different direction. That is the problem because they are getting fund, but apparently that element is there. But you can perhaps, in comparison, what is the, say, your project affected area? So, Article 14, you can come in, but in this repetition is difficult. Yes, there is no reasonable classification with regard to the PAA in second policy and in the first policy.
Yes.
That classification, yes, there is an element of arbitrariness perhaps, but the nature of challenge you have made in this case
is the minutes.
In fact,
minute. And if you go by the policy, then there are regions for this 1% fund and 2% fund. Even if 2% fund and 1% fund, why not Article 14?
Yes,
Why?
that is my submission.
No, that is submission, but that basis is not there. Na? Have you understood
I have understood.
That be it 2% or be it 1%. If it 2%, all the PA families have been given 100%, and us 50. It should not be by in the teeth of Article 14. Maybe you're selling.
What your lordship is indicating is, if 2022 doesn't apply to me,
even then also. Even then also, by the nature in which these PAA families have been discriminated, when from a hydropower project, the effect is same for PAA areas. Why this discrimination in the teeth of Article 14?
Yes, ma'am. That's clear discrimination. They are more affected, but 50%.
But here in this case, Mr. Mazumdar, I don't know if you, I have heard, I can pass the order.
My submission will be let the authority take a decision on the basis of representation I have made, and if necessary, I'll make a fresh representation.
Then we will not go into details.
Need not.
No, my lord, we have already filed our affidavit. It has been heard at length, my lord. And in fact, their own prayer 3 of the writ petition is contrary to what they are claiming. At page 15, prayer number 3 is for a direction to the respondent to recognize and implement the village included in the notification of 10/7/2025. This notification, what is it? At page 68. On one hand, they are saying that 2021 is not applicable. On the other hand, page 68, this 10/7/2025 is...
What is this 68?
Page 68, inclusion of villages in the PAA. Malot, may I read, ma'am? In exercise of powers conferred by clause 9.1 of the Arunachal Pradesh Hydropower Policy 2008, read with clause 28.6 of the Arunachal Small Hydropower Policy 2007 and clause 2.7 of the Ranganadi Hydro HEP so-and-so Local Area Development Fund Guidelines 2021. And on the basis of the recommendation of the Deputy Commissioner Papum Pare, the Governor of Arunachal Pradesh is pleased to add the following villages as project affected area Papum Pare, in addition to the PAA and PAZ notified earlier by so-and-so, so-and-so, so-and-so. Here there is an addition of project affected villages. His prayer is also for implementation of this. For the purpose of allocation of fund.
10/7/2025.
Yes.
Implement.
To implement.
It is already implemented, is it not?
Yes, and this, my lord, has seen...
Issue a writ directing the husband to recognize and implement the villages,
Yes, my
including the notification as legitimate project affected areas.
And this is under the...
Just a minute.
2021 guidelines.
And this is already done, is it not?
Yes, 2021 guidelines. Here it is done under 2021 guidelines.
My Lordship will kindly read the whole paragraph. It says subsequently that in addition to PA and PSA notified earlier by Gazette notification dated
31/10/2022. What is that? Page 60?
63, my Lord.
63.
63. Should recognize and implement the variant.
Yes, this has been done, my lord. This is under the 2021 guidelines.
This will be pleased to issue a writ of certiorari, crossing and setting aside modifying the notification 31/10/2022 so far as it pertains to Papumpari district.
My lord, what my submission is, on one hand, they are saying that 2021 guidelines is not applicable. On the other hand, they are praying that these orders notifications should be implemented.
Since we have heard,
Yes.
I'll decide now. What is this prayer, first prayer?
First prayer is then.
What is the reason for seeking such? That will be page 63.
Well, this 31/10/22 notification we are challenging on the ground that there by this notification certain villages which ought not to have been given any compensation are included.
For what is the reason?
They are not fall under the
What is the basis of your
Prayer,
claim?
they do not fall within the PAA area.
No. Why? PAA areas are defined already.
Yes.
PAA areas are defined by the hydropower policy or the guidelines? By the hydropower policy or the guidelines?
In the policy also it is there, my lord.
In the policy, let us see the policy.
Page 22, Lord, will find.
It's 22.
In fact, my lord, in the policy, Lordship has seen this different definition is given in 2021 policy, my lord.
No, those are guidelines.
Yes.
The policy is at page.
Policy says page 18.
18.
And therein at page 20.
That I think it is not there in the PAA, and this thing is not defined in that.
It's not
defined, Mr. Deuri?
They have defined in terms of radius who are affected, my lord. That will also be find at page 22, my lord. 9.17.
9.1.
They say that developer shall bear the state government's share of 10% of the proposed cost of Rajiv Gandhi Gramin Vidyuti Yojana.
That is different.
Within a radius of distance from the project.
That is first defined in, I think, page 44.
44 is clearly defined, my lord.
Project affected area.
Yes.
Project affected zone. Then functions of LADC, Ranganoti, occupation. It is a big definition.
Yes, man.
Big definition.
Definition is very, very clear.
Area,
yes.
mark dumping area,
Yes.
mine and so and so.
Those areas are directly affected. And beyond that, PSA is beyond that.
Now, what is your reason for the claim that they should not be included? Because they are who is the best domain expert?
sports and that came in.
What I'm saying is, my lord, we fall in the area where there are direct infrastructure, etc. are there. This is an admitted fact. Now, so far as those notifications where they have included certain villages are concerned, like Kimin area, those fall within the surrounding area and they fall within the definition of PAZ. That is why we challenge those notifications for inclusion of areas which are actually within the PAZ.
No, who decides it?
And the government will decide. There is deputy commissioner will decide, ma'am. There is no dispute about that.
And that those notifications are gazetted notification. Page 63 and page.
Yes, ma'am.
68. And that is on the recommendation of the deputy commissioner.
68 also, yes.
Both are on recommendation. And second one also on recommendation.
Deputy commissioner, yes.
Deputy commissioner. And deputy commissioner has made any submission on it. Let us see his affidavit. He has made something, I don't know, I have not read it, but the maps, etc. are included. See, Mr. Mozumdar, page 130.
130.
I don't know what is this.
130.
I have been proposed as P. It is there. See, use map.
Yes.
How can I sit over it as an appellate authority?
No, madam. He has included. But he has.
There will be more stakeholders
in
the PAA in addition to you.
No, they are not saying that they fall in the PA. They are doing it because they are including PAZ also.
No, it is perhaps Mr. Mozumdar, page 63 once again. And 68. It is clear. Says 68.
And if your lordship just has a look at
Formalizing, it's not recommended. First one is both PA and PAZ. Right?
Yes.
Now, second one. This is PAA. In addition to. There is difference. First one is included as PAA and PAZ.
Lordship is referring to which page, ma'am?
Page 63.
Yes. 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 First one is lower subaltern.
These two order,
yes.
PAA and PAZ. Following.
Yes.
And there it is distinction. PAA, Lower Subansiri district, what are the villages as PAA? Next, PAZ.
Yes.
It has been distinguished.
Yes.
What are the villages?
Yes.
Now, all these maps are produced now.
Yes.
With the approval of the chief engineer power in the affidavit.
That's what I mean.
How can I sit it over?
No, I'm not saying that Lordship will sit over.
Yes, 63, it is specific to PAA. 68.
63.
68.
8.
63, it has been distinguished. Yes. What villages will be in PAA, what villages will be PAZ. But 68 is specific PAA.
68, yes.
My lord, 7 villages have been included.
Yes.
Now, I have not read this affidavit, but going by the picture and all, it appears to be detailed. I don't know.
That is all right, madam. But page 68, your lordship, we are also supporting this. 68, our prayer is.
My submission is that this page 68, they are supporting it, but this page 68 itself talks about the guidelines of 2021, notification of 2021, which they are saying that this is no more applicable. On one hand, they are saying that this Ranganadi notification guidelines will not be applicable. On the other hand, they are saying.
Both are 2021 guidelines.
Yes. On one hand, they are saying this is no more applicable. on the other hand, they are saying that these PAA, which are to be included, they have to be included. That is
So I'll reserve the liberty to challenge on the which I have indicated. It will be, I'll observe that. Because otherwise there is a distinction made.
Yes.
Between PAA of other projects with the PAA of Ranganodi.
Lord will reserve our right.
I'll dispose of this.
If they can gain 1% from Ranganadi project, then state will also be more happy. Because it is the Ranganadi HEP who is not giving them 1%. State is already giving.
No, NIPCO you cannot force now.
Yes.
I had Mr. D. Mojumdar, senior counsel. I have to reserve it.
At your
Thursday I'll
lordship,
give.
lordship is unwell also.
Senior counsel estate by Mr. S. K. Deuri, learned counsel for the petitioners. Mr. N. Rotan, learned additional advocate general for all the state respondents.
All the state respondents, 1 to 3.
1 to 3. First up. Anybody has appeared for NIPCO?
No, no one.
One my learned friend is there to take care of all my.
No. Why?
No.
I have no, because Mr. Mojumdar, you insisted so.
I have got no clash with the NIPCO. So NIPCO is a formal party here.
And you insisted, I also proceeded.
No difficulty.
But service report in respect of NIPCO is awaited.
NIPCO will not be affected. The way your office is passing an order, I am challenging the government.
No, I ought not to have taken up this, but
my
because
challenge,
you said that initially very disposal of the representation. I thought that this
NIPCO, I have got no dispute with the NIPCO, man.
Okay, what to do? Since I have heard.
Lordship,
if it is,
as your lordship pleases, my lord.
But after wasting so much time,
lordship,
yes.
Arguments are heard. Husband is reserved.
All right. See it.
All right.
Obliging. And
why Thursday?
At your lordship's convenience.
No, had it been possible, I would have. But problem is long sitting.
There's no such urgency, madam.
Okay.
Item
Other matters, which one is, okay, the last two, 27 and 28.
Item number 27.
I will not take up.
Hello.
Yes.
May I, my lordship? My lordship, today only we received extra copies, so.
Okay. Service report awaited. Mr.
There's.
Nabam.
Lordship.
R. Nabam, counsel for the petitioner is present. Miss, your? K? Learned government advocate for the response number?
1 to 6.
1 to 6.
1 to 6. No. Okay, 1 to 6.
1 to 6.
Has paid for and is granted how much time?
My lord.
2 weeks more.
2 weeks time.
I'm for
To
the,
obtain a
my lord,
necessary
I'm for
instruction
the
and to file the counter.
respondent number 7.
I am dictating, Mr. Counsel.
Sorry.
Don't interrupt.
Sorry.
On behalf of the said respondents. Yes, please tell.
I'm for the respondent number 7, my.
Okay. The respondent number 7 has Mr. So-and-so.
Timite, my lord.
Huh?
Timite.
Learned counsel has submitted that he has entered appearance for on behalf of the respondent number 7 and has also sought for and is granted 2 weeks time to file the counter affidavit on behalf of the respondent number 7. Post up, lays the case after 2 weeks on a date to be fixed by the office. The interim order passed earlier shall continue. till the next regular sitting. Then 28.
Item number 28.
Same, lordship.
Same.
Same.
1 to 6.
Same.
7.
Yeah. Petitioner is different, but matter is almost same.
Same. Interim order?
Same.
Same.
Lots.
Mr. Panging, I will not take up other cases. Almost time.
Yes. All the hearing matters, my lord, I am appearing so either in some petitioner or respondent.
Okay. Late over?
left over. Can this be after 2 weeks, my lord, all these matters, man?
Okay.
In item number 32, there is an entry mode.
You are in petitioner 30, 31, 32.
Yes,
Okay, Mr. Dicky Pangang, Learned Senior Counsel. And
May I please, Your
the Learned State Council are present as sought for and agreed to by the Learned Council for the parties. List the case after 2 weeks on a date to be fixed by the office, or fix that you want.
No, my lord.
After 2 weeks on a date to be fixed by the office. Same order 30, 31, 32. Who is the petitioner in 29?
My lord, in
My lord, in
my
32,
lord, in
my lord.
item number 32. My lord, in
Item
item number
number?
32, I fixed item number 32, my lord. I am appearing for the FCI respondent. A fixed date may kindly be given, my lord, on 19th of May.
Okay, 32 Lighok, Mr. BK Singh, Learned Standing Council FCA, huh? And then give a fixed date in 32.
19 May.
19 May.
Interim order is there, my lord.
Interim order. Interim order 32 continue. 30 and 31, no interim order?
No, no, my lord.
Okay. This is after 2 weeks.
Madam.
And 30, 29.
Yes.
Sonar.
Yes, I'm appearing on behalf of Sonar.
Okay. Mr. So-and-so. Learned Counsel for the petitioner, Mr. D. Panking, you are for private respondent?
Yes, madam.
Learned Counsel for the private respondents. And who is the public prosecutor?
I am for respondent number 2.
Oh, respondent number 2. You are for 1. 1 means state. State. And Mr. D. Panking, Senior Counsel for the respondent number 3. When do you want? After 2 weeks?
May I please, Your Lordship? In item number 30, Your Lordship, I'm for respondent number 5.
Okay, just a minute. Let me pass the order in 29. Okay, list the case after 2 weeks on date to be fixed by the office. Okay, item number 30. Your name is to be registered. Mr.
No, I have a prayer, Your Lordship. If possible, Your Lordship, a day after tomorrow, can it be fixed on?
Not possible. Only few matters are fixed.
Problem.